Hi Jake, this is Drew. So are you there?
I am.
Okay, so we're going to go through the formalities of explaining why you're there, etc. After we've actually opened the meeting. We haven't opened the meeting yet, so we'll start that now. Okay, so you all set? Yeah. Okay, so it's just after 6 o'clock on May 15th. This is the Madison Zoning Board of Adjustment at our regularly scheduled meeting. Come on in. And we'll start with Pledge of Allegiance. Sharon, would you lead us?
Certainly. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We have a full agenda tonight. We're going to take case 2315, which was continued from last time, and case 2318. In all likelihood, the vast majority of the other cases will be continued or tabled. And then we have a case to consider for a rehearing that must be heard. We must decide that tonight because we're up against the 30-day deadline. Which means that we'll be getting to cases 2403 and 2404 probably late. Our rules of procedure are that we don't start new business after 9 o'clock. And we will end the meeting by 10. So for those of you that came for 2403 and 04, I hope we get to them. But just understand, there's a possibility that we may not get to both of those cases this evening. Also, we will need to elevate Jennifer Scaife, who is on alternate for these first two cases at least, and so we'll just pick up where we are. So where we are is with case.
Did you explain why Jake is on the phone?
Oh, Jake is on the phone. Yes, I want to get into case 2315, and we will, as we do that, we will explain it. So, okay, so Jake, can you speak? Say hello.
Hello.
Can you?
It's up as high as it'll go.
That's up as high as it'll
Can you
go?
turn it more towards
Yes.
the, this way? Because that's
Mhm,
as high as, I
okay.
think it's at 10. Yeah, and I did it up as high as I could go.
Volume, okay. Are we at 10? Okay.
Oh,
No,
Wait a
we're
minute.
Jake, keep talking.
Talking, test
that's,
one.
there you go.
two,
That's as
one.
high as it goes.
Okay, so Mr. Johnson, can you hear that?
I can.
Okay, so I have a series of protocol questions I have to ask. Jake, can you state the reason why you are not able to be in the room tonight?
I'm on vacation in Washington, D.C.
Okay. The procedure requires that a quorum be physically present at the location of the meeting. For the public, we have elevating Jennifer. I'm here, Sharon's here, a quorum is 3, so we have a quorum. We have a 4-member board. We have informed Mr. Johnson earlier that we can't put a 5-member board together tonight, and he has agreed that he wishes to proceed. For those of you who have a case later, do have the option to continue the case without a 5-member board to wait. Okay. So we've confirmed. Jake, can you hear us? Mr. Johnson, can you just speak up just for a moment?
Test, test, test.
I can hear him.
Okay, and you can hear, Mr. Johnson, you can hear Jake, you said.
I can.
Okay. So the public at the meeting location must also be able to hear the person who is not present. Does anyone in the room that's interested in case 2315 cannot hear Jake? Okay, I'll take
Testing,
the,
testing.
I'll take it that you can hear him. Okay, Jake, you must identify any other people who are in the room with you. It's a public meeting, it's a public hearing, but we're required to identify anyone who's with you.
There's nobody else with me.
Okay, thank you. All right, so we will proceed with the 4-member board. Case 2315, we were at the stage basically of coming up with preliminary findings of fact. we are still in a public hearing, so we will be able to take additional comment. I will review the findings of fact as they state at this point so that we have a common ground, and then I will allow, I'll allow Mr. Johnson opportunity to add anything new to the case before we consider there. So these are our preliminary findings of fact that we identified in the meeting last night. The primary question is whether there is a valid claim to be grandfathered. Excuse me, we probably ought to go back. Kate, let's read the public notice from the last time, and we'll just review so that we know we have all the formalities covered here.
Case 2315 continued from October 18th, 2023, November 15th, 2023, January 7th, 2024, February 21st, 2024, March 20th, 2024, April 17th, 2024. Appeal from an administrative decision from Matt Johnson, Esquire, Divine Nomad Branch PA, agent for Keith and Allison Kellerman, 21 Haven Road, tax map 128/21, to determine whether or not their circumstance allows for short-term rentals related to a denial from Robert Boyd, Code Enforcement Officer, dated August 16, 2023, as to Article 4, Section 4.2 of the Town of Madison zoning ordinance. And everything has been posted. This was posted on, the notice was posted on April 24th.
Okay, thank you.
You're welcome.
Since Jennifer, you're sitting new on this, do you have a conflict of interest?
I do not.
Do not, okay. We previously polled Jake for conflict of interest. He's not, I have none, and Sharon previously said there's no conflict of interest. We previously determined that in this case there was a waiver request and we accepted it, I believe. Like it's irrelevant because there's no dimensions. And there's no regional impact. Okay, so we are at the point of the preliminary findings of fact here. Primary question is whether there's a valid claim to be grandfathered. The home is in the Silver Shores Homeowners Association. Silver Shores Homeowners Association was chartered in 1976. Currently has 13 homes, 11 of which are rented seasonally, as has been the habit at least for some since approximately 1976, which was a testimony of Mr. Audette, who was the vice president of the Silver Shores Homeowners Association. The HOA charter foresees rentals without distinguishing between long or short term. Mr. Audette and Mr. Johnson stated that the charter of 1976 provides the homeowners with the right to an existing non-conforming use. We have testimony from Mr. Knight and Mr. Audette that the Moores, who were the owners from 2015 until the Kellermans purchased the home in December 2022, were part-time residents who rented the home out regularly every year. They estimated that at perhaps 60 days or more per year, however, without documentation. Just to be clear, that is after 2015. The Moores declined to provide testimony or documentation, preferring not to get involved per Kellerman's testimony. And prior to 2015, the home was owned by the Davis family, who were full-time residents and therefore were unlikely to have rented the home at all, per Mr. Audette. That is the current status of our findings of fact. Mr. Johnson, do you wish to add, re-emphasize, or amend?
I would. I appreciate the board's indulgence. I'm going to hand up a couple things, and maybe I'll do it all at once since there's not too much paper, but I'm going to hand the first document. And, I did send an electronic version of this, so I don't know if Jake had a chance to get it digitally or not.
Jake, did you get a copy of that digitally?
No, I didn't.
No.
It's okay.
Okay.
So the first thing is just at the last meeting, the board wanted to see the complete copy of the charter document, so I pulled that together for you. And if we stay on that document for a moment, I apologize for using the front of this as a desk, but I'm going to use the front of this as a desk.
That's all right. And Jake, what we're doing is we're looking at a complete copy of the Silver Shores homeowners or HOA document, so.
And so the first 1, 2, 3, 4, 5 pages are really the original, the articles, and then we move to the Silver Shore, Madison, New Hampshire restrictions. And that is where there is reference in paragraph 3 and paragraph 6 to the rental. It says no part, paragraph 3 says no part of the land and no building or structure placed thereon shall be used in the conduct or carrying on of any trade, business, or occupation of any kind whatsoever, except that the premises may be rented for occupation as a residence. And then paragraph 6, these covenants and restrictions, and each of them are hereby declared and agreed to be covenants attached to and running with the land, and shall continue in full force and effect until amended or modified by the written consent of all the lot owners. And then if you skip to the back of the document, there is also the Silver Shores rules and regulations. And in the statement of purpose, at the very end of it, it says these rules and regulations apply to all lot owners, guests, and renters of Silver Shore properties. And then under the general regulations, paragraph 9, those renting properties should use discretion as to the number of persons allowed the use of their property in Silver Shore facilities. And then at the last page of that document, there's an enforcement section. And the second full paragraph states copies of Silver Shore's rules and regulations should be available in each cottage for information, guidance, and compliance of all. Parentheses, this is especially important in rented cottages. So would just reiterate that this was from 1976, that predates the passage of the Madison zoning ordinance, so I would submit that by virtue of these documents and this permitted rental use and the prior testimony about the rental use, that Mr. Kellerman had a pre-existing, now non-conforming use, and so is grandfathered to be able to continue to rent the property, as we talked about at the last meeting. The next document I'm going to give you is just some confirmation of Mr. Kellerman's testimony at the last hearing, and this is just a document which shows the first rentals of the property after they acquired the property. And then the last document I'm going to give you is an update that Mr. Kellerman had for you to show the number of days that he had rented the property through December of 2023, just to corroborate the fact that his use has been consistent with the testimony from the last proceeding of roughly 60 days a year of rental. And so those were the additional items that I thought were important to clarify or provide additional context for the board relative to both how Silver Shores had operated fully and how Mr. Kellerman has operated the property, so that there's no abandonment of the use of the short-term rental activity.
Okay.
And with that, I'll take any questions the board might
Tim
have.
Johnson, can I just have copies of those for my, I need them for my file, sorry.
Jake, did you hear that?
I'm sorry.
Yep, I was able to hear all that.
Okay, so,
Do you have more?
yes, so the effect of that is that we have confirmation of the rental as presented last time when you were here, and we have confirmation of the rental period beginning in 2015. Okay. Does anyone from the public wish to speak to that item? Let's see, you weren't sworn in last time, though, were you? No. So all right, does anyone else wish to speak to this case? We'll just swear all of you in who wish to speak to this case. I'll stand up, please. Just a moment, let me get my script. So raise your right hand. Do you swear that the testimony that you give pertaining to this case will be truthful under the penalty of perjury?
I do.
I do.
Okay, and when you speak, come to the microphone and state your name, so we have a person who's... And I'd like you to be relevant. Let me just make one clarification for the public here. With respect to the question of grandfathering, one of the questions we have to answer is grandfathering before 2022 or before 1987 is the question, is one of the questions we have to answer. Okay, so.
Thank you, Mr. Chairman. Kathy Kozel, 7 Lakeview Drive, Madison, and Idleweiss. And I know it was discussed at last meeting, I did watch it streaming, and that there was testimony that the prior owners, which last name of Davis, owned the home, used the home, and didn't rent. But that was sort of hearsay from an individual that I don't know if he was president of their association, but lived in that neighborhood. Since then, we did have an opportunity to reach out to one of the family members, and even though the description of the property use from attorney Matt Johnson stated that it was historically used as a short-term rental and had always been used for short-term rentals, and that use had never been abandoned, we do have...
From 2015.
So-
There's a caveat.
Okay, but just to give documentation for prior testimony from a
Yeah.
family member. Mr. Alan Davis, I received your letter regarding my family's vacation home at 21 Haven. My parents built the house in approximately 1968. We used it year-round on weekends and were there full-time during the summers. It was never rented prior to 2015, when they sold the house after it became too difficult for his parents to make their trip to Florida. So just a statement from an actual family member to confirm or corroborate what was
Okay,
said at that
that
meeting.
corroborates what's
Yes.
been asserted, that the house was rented first in 2015.
Correct.
I'm gonna object because we haven't seen the letter. This is
Okay.
a letter written by somebody who's not here. They're not sworn in. You can't swear her in to talk about what somebody else wrote.
Well, it's, we could be very picky units here. However, the testimony corroborates what you already asserted, that is that the house was rented first in 2015.
Yeah, and there's some documents showing that Mr. Alan Davis was a trustee of the family trust on behalf of his parents. So there's some other deeds and quitclaim deeds that confirm that.
Okay.
So, and I think I did send this to the office,
Yep.
but it was Friday. Okay. Okay. If you want a copy of this,
Do you have
Attorney
copies
Johnson?
with quitclaim deed?
You want a copy of that email?
I have that.
I can get it.
Okay. Okay. Thank you.
All right, thank you. There were several other people who wished to say something.
Mr. Chairman, Bill Dempster, I have a question for the board. It was an open, sort of an open item from the last meeting, and that is one of the reasons for the continuation of the board is going to ask the attorney about precedents of the homeowner association versus a zoning ordinance. And my question to the board was, was the attorney contacted, and if you could share that with this meeting? Thank you.
Yeah, I would simply say that the board has done research into that, and in our deliberation, we'll be able to discuss the results of our research. Okay.
Thank you.
Other comments or questions? Go ahead.
Nick Borelli, Madison, I Lakeview. Far as precedents in the building trades, what happens is in towns or cities, wherever you are, or HOA, whatever, whether it's a setback, whether it's a building code, or anything like that, it always goes to the strongest ordinance to protect the neighborhood and the people around. That's, I'm gonna say, in this case, same thing. The town's ordinances that were put in place back when zoning was introduced in '87, the HOA, no matter what it says, it would actually have to go to what the town or state has in place. In far as non-conforming use of land or building which is entitled to protection against zoning provisions, and one that was lawful when it was restriction from their prior property at the time of the amendments of a Keene zoning ordinances in 1955 and 1957 did not exist lawfully, cannot be given the protection of non-conforming use. Provisions which accept existing uses are intended to favor uses which were both existing and lawful, not to add uses who have succeeded in evading previous restrictions. That's 35-60, quotations omitted. That was a Keene case, number 104.
Any other testimony from the public?
He was sworn in.
Yeah, yes.
Mr. Counselor.
Yes, and we've heard your testimony before, so if you're going to give the same testimony, feel free to summarize it because you gave it and we have it in writing. Go ahead.
Just mix this up. It's really short. So,
State your name and,
yeah, I'm John Cancelarich, Melrose, Massachusetts.
I'm sorry, what?
I have a house in Edelweiss Village.
Do you have an extra copy?
I do. Yep.
Can you provide one to Attorney Johnson, please? Thank you. As you-
So I won't go too much, I talked before, but the big thing is in our, if you go to the third page, which basically lists the articles that are important within our zoning ordinance. And the primary thing is this is permissive ordinance. Under our purpose on 1.1, I will state here that you guys, the board has the right to control the usage, as we know, of how people use their property. The second part is this zoning ordinance by application provision of state law seeks to protect existing property owners against a new use nearby which may be incompatible or undesirable. That's in our purpose. 2.1 gives us the right to enforce. So the selectmen, if they do not initiate, we can do not waiver. 2.3, compliance requirement. This is usage, so as long as it only confirms with the permitted use in the ordinance is allowed. So we are permissive use in Madison. So what I did is you look at Article 4.1, land use hereby permitted for each district is listed for rural residents is 4.2, which is a permitted use, and I read it right here. It is mainly a district of farms, residents, and woodlands. The next part that might apply to this is number 3, which is single-family houses. And lastly, the big thing that I recommend in special exception, if we go down to number 7, which is lodging house, bed and breakfast. These are the primary things that are applying here. When we do this, based on what they did in the Portsmouth case, is we try to define things, define our ordinance. Bed and breakfast is a privately occupied residence with guest house. Okay, motel is in our definitions, not included in there, but it's important it's in there. Undefined terms, 2 of them that could apply here, residence. We use the Webster's third because we don't have it. We can look up common dictionary of it. Defines residence as an act or a fact of dwelling in a place for some time. It's showing kind of a temporal time frame to it. Single family house, Cambridge Dictionary states it as relating to or involving houses or apartments for one family. And the American Heritage Dictionary states as relating to or being a dwelling desired for one family only. These are important terms that we have that are defined because we're permissive. The other term we have, the only thing that kind of applies to this short-term rental is number 7, lodging house, bed and breakfast. That is strictly defined as, in our ordinance, once again, as a private owner-occupied residence with guest house. The key parts here are that the only transient kind of lodging permitted in rural residence is owner-occupied bed and breakfasts. It was purposely put there, okay? There's a certain rule that we have when constructing, when we construct the, 1 second.
Tell us which page you're on when you,
Okay, we're on second to, if you go right here, second to last page, it starts with, this is conforming by relating rule. Yep, right there. Permissive, I think we all understand, we've been talking about that for a while. This is conforming to a related rule of construction commonly summarized by Latin phrase expresto unius ex excursio alteris, indicating that an inclusion of one thing of a particular type is statutory necessary implies the exclusion of all other things of the same type. I gave certain, you can see in here, some of the actual rulings that have come out, where it specifies which entities can possess the right to file a petition to the committee, and where not added to list in the absent is not, that's their intent. On the very bottom, Silver Richards Botch, there is evidence of the contrary. Statutory itemization indicates that the legislation's intent to use the list to be exclusive. Okay. What I'm saying here, it's clear. The drafters of the Madison zoning ordinance indicated only one form of public short-term lodging, that an owner-occupied lodging house, bed and breakfast facility may be allowed in the rural resident district. It's important. Also, there's been no provision made to offer charge by night lodging, which is an STR, in a vacant single home houses. Neither the ZBA nor the courts have the power to add a permissible use category that the drafters of this ordinance did not indicate. The same conclusion by the rule of statutory may not be construed in the way that renders any of its provisions superfluous, like useless, because such a reading would be inconsistent with the drafter's intent. There is a reason for them putting it there. And I gave a couple of court cases on that. The problem we have here is the STR people, proponents, are saying that any home in the rural residence can be offered for lodging in his house for paying guests for as little as one night without a provision of special exception, and it would make the actual bed and breakfast useless as a rule, because all the bed and breakfast person has to do is just leave his house. Now is he an STR? There's distinction here. The Supreme Court themselves, by the ruling, has also ruled that these type of short-term rentals are consistent. They're very much together in how they are a pay per site. There's a common thread here. Pay per site, people use it on a pay per daily basis. We specifically defined what we allow in rural residents. We went so far as to say that in the village district, we allow bed and breakfast and also an inn type. This type of STR kind of renting pay for per day business at your house. So by allowing STRs, you're making that rule useless. It doesn't apply. There is intent here. By law, we cannot just throw it out. We have to follow that intent. Since the goal was to preserve the character of the rural resident in the district, farms, residents, and woodlands, such the owners wish to merely offer guests out in a private, owner-occupied resident must go through special exception so that we can notify abutters, prove his satisfaction conditions, so it won't be a nuisance, setbacks, traffic, parking, property values, and safety. It's absurd to include that owners who wish to offer an entirely vacant house to transient visitor on an unsupervised, charge-by-night basis could do this with impunity. We defined it. We can't change, you can't add to this. It's permissive only. It's equally absurd because in the village district, they can't operate in without it. So you would throw that out as well if you allow STRs to exist here. If they need it, it should be put into law. We have laws in here and you have to follow it. Okay. He's also mentioned that in correspondence that he advocates, says that STR restrictions are competing with all these bed and breakfasts, commercial entities, and tourist industries. So he stated that they are similar in use. When we list one, it's at the exclusion of all the others. This town has stated that this kind of short-term renting is for only occupied households under special exception. Okay, thank you very much.
Okay, just one second.
Sure.
Jake, do you have any questions?
No, I was able to hear him perfectly throughout the whole thing.
Okay. Jennifer, Sharon, do you have any questions? Okay, thank you.
Thank you.
Does anyone else wish to speak to this issue? If not, then... Okay, then let me, what I haven't heard tonight is what I would consider to be a significant amendment to the findings of fact that we had already listed. We have heard, that is, I don't see any changes in what we said. What's important for the board, I'm just going to say, because we're going to start a deliberation and there won't be any opportunity for the public to speak, right? So the what's not in question here is that this house was rented regularly after 2015. So if the date that qualifies for grandfathering is March of 2022, then this house was a pre-existing non-conforming use prior to 2022, and under the state's, no, that's, the point is, if 2015 was the date of the first rental, and 2022 is the date that establishes the right to grandfathering, then this is what we have to decide. If 1987 or 1990 or 2010, depending on which version of our zoning ordinance you want to read. However, the zoning ordinance in 2015 already has all of the provisions which were mentioned, which we've checked and double checked. So the 2015 version of the Madison zoning ordinance also predates the date of the sale of the house. So if the 2015 and earlier ordinances establish the fact that short-term rentals were not permitted, then there is not the right to be grandfathered, right? That's what we're trying to decide. So it's not whether or not the house was rented from 2015. We're going to grant that, and it's about approximately 60 days a year. So what we have to decide is whether or not the critical date is 1987 or 2015. One of those ordinances in there, it actually doesn't make any difference, as I said, because all the provisions that have been mentioned are in the ordinance in 2015. Does anybody, last chance, Mr. Johnson, do you wish to underscore anything else?
I would just reinforce that in our position, it's the March 22 date that matters for the reasons I've articulated before. Otherwise, under the pre-existing ordinances, these were all permitted uses as single-family dwellings and therefore permitted to be used, and there was nothing restricting short-term rentals until the March 22 ordinance. And I would note that there was zero enforcement action ever by the town for short-term rentals until after the March 22 ordinance, is further proof that supports the fact that it was the March 22 ordinance change, the change to make short-term rentals no longer permitted, and then triggered this proceeding.
Right. The other thing that we have mentioned here in our findings is that the HOA had a provision for a for rental and foresaw rental from 1976. Our laws change all the time, and in 1987 the zoning ordinance in its original form took effect. Any home that was already established in 1987 that was currently renting had established a pre-existing non-conforming use at that time. A home that did not have the use would normally not be considered to have the right to establish a new use under the current ordinance. So, can I entertain a motion to close the public hearing and then we'll begin deliberation?
So moved.
Second.
Okay. Okay, well, we got a second, so is there any other discussion? Any other comment? Jake, any other comment?
No, I was gonna second.
Okay. All right, all in favor of closing the public hearing?
Aye, yes.
Aye.
Aye.
Jake?
Point of order, doesn't this have to be roll call because I'm by phone?
Yes, I'm sorry.
Sorry.
Yes, I have been doing person by person. Sharon, stay here.
Aye.
Jennifer?
Aye.
Jake?
Jake, aye.
Drew, aye. Okay, so we're closing the public hearing, so we will now enter deliberation. There's no further contribution from the public, and we will discuss this case. Okay, so I guess at this point, I've summarized these facts. For the ease of communication, Jake, I'd like you to respond first to this question. As I just mentioned, this house was built in 1969, but was never rented until 2015. And so therefore, my understanding of the statutory basis is that the zoning ordinance of 1987 and the zoning ordinance of 2015 take precedence in terms of determining what use is legal for that house. Does anybody wish to debate that question or? Okay, so then the question that we have regarding the right of the homeowner in 2015 to rent the house based on the HOA charter is that it was superseded by the ordinance at latest of 2015, since that use had not existed at that until 2015. On the assumption that, the 2015 ordinance denies the right. Now, the point though is, so we have to decide whether or not the ordinance in 2015 and earlier denied the right to a short-term rental. Does anybody wish to speak to that from the board? Or shall I make a proposal about which we can discuss?
Make a proposal, we'll discuss that.
Okay. Okay, so if we take a look at the ordinance, on the one hand, as was presented, if we take the definitions of things like business, commercial use, motel, in a permissive ordinance structure, then the short-term rental is not permitted in that it's a hotel. On the other side of the coin are the people who say, well, if there's no specific definition available of short-term rental or a time frame, then how can one distinguish between residential use? And because there's no doubt that an owner may rent his home for months or years, that's not a problem. That's not what we're considering here. The question is, well, if it's 3 nights, a week, spottily, 60, 100 days a year, when the owner's not there. The question is that fundamentally different? Does our ordinance sufficiently specify the difference between that kind of use as a motel and a long-term rental that we can say that the ordinance out? Where I'm gonna go with this is that I suggest that we take the basis of the 2 primary court cases we've discussed, the one in Portsmouth and Conway versus Kudrick, which underscore that the issue is the wording in the local ordinance because there's actually no state guidelines. So what we have to decide based on the strength of the wording in our ordinance as to whether or not that residential use is suspended when we're using something that's short, like a couple of nights and the owner's not there.
And I agree. I'd like to at least start then maybe with the very beginning of our zoning ordinances with the general purpose, where you look at and it says encouraging uses that are in harmony, there's other words in there, visually and aesthetically with rural living. Now, rural living would indicate that people are, living full-time in their houses. They may be farming, they may be cutting wood, they may be doing a number of things that are listed in here as permissive. But what they're generally not doing, I would think, is renting them out on a nightly basis. Those are functions that I would suggest do not lend themselves to rural living, but lend themselves instead to another district, a district that perhaps has not just commercial, but other residential purposes. This is a residential-like purpose where people are sleeping, bathing, eating. I would not necessarily define this as people who are doing rural living. And that's in the very general provision of our ordinance, and has been since they were created in 1987. That has never changed. The general purpose has never changed. Over the years, we have added some definitions in order to add clarity, but I believe the general provision has never changed.
And to piggyback off that, our zoning ordinance does allow you to run a business out of your home, seeing as long as you are living there, running the business. But it has to be your home. You can't erect a gas station in a rural residential district if you know what I mean. We are still permissive, but we have certain criteria that has to be met. So, following that guideline, yes, you can run some sort of lodging establishment as long as you go for a special exception for a bed and breakfast.
Yeah, the bed and breakfast is the special exception.
Yes.
Okay, so what I'm hearing, just to summarize, is that on one hand, we have a purpose statement that defines rural living. We have a permissive ordinance that does not list an activity that sounds like what is defined as a motel. The motel definition, by the way, includes the fact that it could be a single building. It doesn't have to be multiple buildings. Jennifer, do you wish to say anything? You don't have to.
I would just like to say just one thing, it's sort of a minor question, sorry, addressing everyone, is rural living, very clearly stated, no, I live that life. Is there any mention of vacation or part-time? Because rural living, if one is to take the implications of it, is 12 months a year. And a lot of homes are vacation homes or part-time homes for their owners. They don't live here 12 months a year. I'm not so is there a definition, is there anything that defines something as being a holiday home, a vacation home, that is defined in there, with respect to rural living, but not 12 months a year rural living, because by definition that's kind of very much farming and, like what you read. Is that even relevant? It just as a thought.
Well, no,
that-
it is potentially relevant because it helps define what a residential use of a
Right.
home is. Clearly, if someone owns a home in Madison, there are some statutory framework questions that are applied to, if you live in Madison 3 months a year, you can't actually be a resident.
Right.
You're a taxpayer, but you're not a resident of Madison. You can't have a driver's license in New Hampshire unless your primary residence is in the state of New Hampshire. You can't vote here unless, you, et cetera, et cetera. So there are some framework questions that answer that. But no, there's nothing in the zoning ordinance that would prohibit, for example, a person from owning a home in Madison and occupying it, let's just say, for a month a year.
Right, and sailing, and not doing any rural living.
Oh, well, one might argue that it's
part of
rural living when they're here, but the question was whether, what you're asking is
Yeah.
whether is 4 weeks a year living in the home
Rural living.
rural living, and if by definition it is, then how do we deal with it? As I said, the question that has to be answered is how do we put a time frame on a short-term
Right.
rental? And when did we actually put in the term transient, Kate? Did that come in?
I would also,
my time.
while she's looking for that, Jennifer, I would also say that an individual who owns a second home here is the owner of a
Yes.
home.
Yes,
And they do have the right to be in that home
Yes.
as little or as often as they like.
that's where I was going.
Yeah, no, and I do still consider that rural living because it is that owner's structure.
Prerogative.
And
Yes.
it's their prerogative as to how often they're there.
Yeah.
This could be my primary residence and I'm a 365 person who owns, this is my only residence, but I could still travel the world for most of the year, and that doesn't negate rural living.
No,
So I think the issue of, a second homeowner not understanding whether or not that the transient piece applies to them or doesn't apply to them is it's non-existent. It's silly because they, as a homeowner, have a right to use their home.
Yeah.
They get to use their home, not necessarily rent it out for a single night here or there.
but if they were to use it for just
One
3
night a year,
weekends, yeah.
it's still
Still
considered.
their it's
It's
their home.
still their home. They
Thank
own
you.
it. They're a homeowner.
That's clarified my thinking.
Jake, you want to comment on that so far?
As a second home, if I believe by the ordinance, it prohibits you from running a business out of your home. Correct me if I'm wrong, but I think it says it has to be your primary residence.
Oh, if you're running a business out of your home.
A home occupation kind
A
of
home
thing.
occupation.
Yeah.
Yeah.
I believe you can't run one out of a second home because you'll go away and the business will still be there.
Oh, yeah, you have to be present. No, that's true, although that's not relevant directly to our
To this,
question, because we're discussing whether, yeah. If-
And some other points that I'd like
Go
to
ahead,
make,
go
but I
ahead,
don't
make
know
it.
that they're in any necessarily particular order.
Okay, go ahead anyway. Jake, you can hear Sharon, correct?
Yep.
Okay. Well, one of the things that we had discussed was the HOA and the fact that the HOA creates rights for those homeowners, or created rights for those homeowners to be able to rent their home out. And while it did not give the definition of the length of time that they could rent it out, needless to say, this particular homeowner, going back to that time frame, never rented out that home until 2015. And so my understanding and my stance is that a pre-existing right that gets unexercised does not create a non-conforming use. You didn't exercise that right. They never actually rented the home out. So you can't say I had a non-conforming use back to 1976 when it could have been rented out, because it never was. Regardless, the permissive regulations that we have as a zoning ordinance, regardless of whether they're 1987, 2015, 2020, 2022, those regulations, those zoning regulations, carry the weight of precedent over a homeowners association, because the regulations become more restrictive. The homeowners association cannot create a situation where they are more lenient than what either the town, the locale, the municipality, or the state says is the zoning regulation.
Except in the case where the use was established legally
Correct.
in a pre-existing, because we cannot take a zoning ordinance and apply it retroactively.
Actively,
Right.
correct.
So that's why this question is important, because we can't take the 2022 definition and apply that definition retroactively unless those restrictions already existed in the ordinance.
Correct, yeah. Again, hence the reason that not exercising the right to then rent your property prior to the 1987 zoning regulation does not create the non-conforming use. I was talking, the motel definition is included specifically in our zoning regs prior to the 2015 timeframe. And while it's not necessarily, it's not used in any of the particular district regulations, the Article 4.2 or 4.6, again, being permissive regulations, the fact that it is absent from those pieces says that that use with that definition, the motel with that definition, was not allowed.
Kate, did you,
Hold
yes.
on, let me read you a little blurb, okay? So the definitions that were added by the planning board in a vote of town meeting, which were accessory dwelling unit, accessory building or use, transit, and non-transit, were incorporated into the zoning ordinance by the land use administrator, not me. They were put with the article, not in the definition section where they should have been. When the 2018 zoning changes were incorporated into the zoning ordinance, the new land administrator, still not me, moved those 4 definitions into the definition section of the ordinance.
Excuse me, that was 2018.
Yes.
Excuse me, but those definitions already existed in the
Just
ordinance.
didn't get into the
Definition list.
correct.
Okay, but
And
when were they added to the text?
2015. So, and just for informational purposes, we have yet another land use administrator. So they went through a couple of land use administrators and things did not get, they were decided on and voted on, but did not get into the actual zoning ordinance.
Clear as mud.
Before my time, I was not here,
No.
just so you know.
Okay, that's a broad statement. Did any of those, I thought we'd researched this. Okay, did any of those statements that did not get transferred from the warrant articles into the zoning ordinance, do any of them relate to the short-term rental question, motel definition, transient issue, et cetera, et cetera?
Well, they
Other than the fact we've established that those definitions that we just talked about were actually in the ordinance in 2015, they just weren't actually listed in the proper category.
That's how, yes, that's what I've been, yes, that's what I've been told. That was before, it was
Okay,
10 years before I started here.
okay. Well, the question that I was asking was whether, okay, but 2015 is a critical date for us, because that ordinance, the way it was published in 2015
In 2015,
predates the sale
they
of
added
ours.
accessory dwelling unit to the ordinance that year,
It added accessory dwelling unit.
in 2015.
Did it add
The
transient?
definitions were also added that year. I just
Transient?
read, by the planning board and vote of town meeting, which were accessory dwelling unit, accessory building or use, transient and non-transient, were incorporated into the zoning ordinance by the land use administrator
Okay.
at that time. They were put with the article, not in the definition section where they should have been.
Right, but we didn't have the word transient. It was defined, but it wasn't used in the context of any of those definitions like motel or rental or anything like that.
That's-
Okay, so, yeah. All right, so I go back to the fact that it's important that when someone reads the ordinance, that they understand what the ordinance means in plain language, right? So if one has to go through a bunch of machinations like that in order to understand what the ordinance meant, that's quite complicated. However, if it's clear that is a permissive ordinance, that you're not allowed to have a motel style operation, then the burden is on us to show somehow or another that a non-owner occupied rental is in some way a motel, right? We can just focus on that for a moment, because that actually, I mean, we can anchor the question on, is that a motel? Because if it is a motel, it's not permitted, right? And that's a definition that's really not easily disputed. It's quite clear. And as I think, trying to keep you engaged here, Jake, but would you agree that the real issue is establishing a time frame? You know, like, is a motel, if someone rents it out, their house out 10 nights a year, 15, 20, 30 nights a year? I mean, or do they have to be an absentee landlord and never live there themselves? Then there's, I mean, that would clearly be a situation where it's a motel.
Yeah. I mean, that's a difficult question, because we've heard cases about people who have never stepped foot in these houses that they are appealing. And then we've also heard cases from people who are like, oh, we only rent it out during the summer for 1 month. So, yeah, defining what constitutes the motel, I think, is pertinent.
Okay, so we need to. Okay, well, it's fairly clear in this context that it's not a bed and breakfast for two reasons. There's no existing hearing which granted
The special
the
exception.
special exception. So that's absolute, that's clear, right? The other thing is it's also not owner occupied during the residency. So bed and breakfast is a category that doesn't apply to this case. Okay.
Correct.
Okay, so then the only other category, because what we're searching here is, do we have clear language? Because if we have clear language, we need to work off the basis of that clear language. Motel, excuse me. A building or series of buildings in which lodging is offered for compensation with direct or independent access to an adjoining parking lot for each rental unit. No mention of time frame. I think it's fairly certain that the owner is not necessarily part of the residential experience of the individual. They might have a room in a motel office, behind the office, but you know, it's independent living in a motel. So like I said, do we think, is the issue here then, I mean, what's reasonable? Is the definition then of a motel that it's an absentee landlord, or that it's a transient for transient occupation, or regularly for transient occupation? I mean, that could, and how can we link the transient definition to motel?
It becomes very subjective, having worked in hospitality for a huge amount of my career. And
Excuse me, Jennifer, say that
I
again.
I worked in hospitality for a long
Okay.
time in my career, so I have an interpretation of both hotel and motel and some of the differences. But I'm trying to stay on point rather than having
No, that's fine.
a subjective opinion here. But there are expectations with a motel, are that there is some form of service. Limited. I mean, there isn't a restaurant, there isn't necessarily morning coffee, and, any of that stuff. But there is someone you can call and say, now I'm saying this could be also short-term rentals. I'm just trying to run what a motel expectations are, that you have a private space, you definitely can park your car, you've got your own front door very often. There is always someone on call. Now that doesn't mean that the office is open 24/7, but there's someone on call if you needed assistance in some way. There is compliance. There are compliance issues with the ADA with a motel. Again, motel. It is a it's an environment where it has to have certain compliance issues. And
Yes, although,
That's a relatively recent concept.
yes,
More
and
than hospitality,
compliance
but-
issues, if you have more than 4 people who are not in your family staying in your residence,
Right.
you establish certain compliance issues which are outside our zoning,
Yes.
purview of zoning.
Not ours,
Right,
yeah.
so
Agreed.
we don't,
yeah, no, but I'm just saying,
Yeah.
I'm describing this hospitality experience that is a motel, and as I do, it doesn't differ greatly than staying in a
Short-term
residence.
rental.
Yeah, and I mean,
Yeah.
there are people that live in motels, don't get me wrong, we know that, but they're generally seen as transient, even if people stay long-term, they're still defined as transient, actually. So the motel definition has some legs, I believe, here, as abstract as it seems when we first started talking about this. I feel that it's,
when you say it has some legs, meaning that
it has some relevance, I beg your pardon, yet
Yeah.
it's appearing to me by language, and that is what we're talking about here, semantics and language, actually. And I'm not a lawyer and never have been. I have no wish to be.
No, but there's a reason why the zoning board of adjustment
Right.
is not made up of professional attorneys.
Indeed,
It's made up of people who understand language the
Yeah.
way it's spoken on the street.
right, yeah, and we're residents of this town.
Right.
So anyway, without taking up
No, well,
airtime.
complete your thought,
But
yeah.
the thought is that as I describe what my understanding of a motel is, it doesn't differ greatly from allowing complete strangers to stay in a residence, a home.
Okay.
That's my 2 pence.
Which is actually, shall we say, from a legal perspective, distinguishable from someone who even for a shorter period of time would have a rental contract for, say,
Month to month.
month to
Right.
month, or, they're
Totally different.
totally different arrangement than something that's quite intended to be, 2 days this week, and maybe we'll stretch it out to 5, and
And we'll come back next year.
we'll come back next year. It's vacation, or you're a worker in the local area,
Yep.
and you've got a job that you need
And
to
the
do for
company
4
pays
days.
for it.
Company pays for it. Doesn't really matter.
Yep.
You might extend it to 7 days because the job took longer.
But you do expect something for that. You expect, that the property is serviced in some way. It's cleaned, there's some element of support, you're not
And
just
if-
left
and-
to your own devices.
Yeah, and you're not left to your own devices, and in between whatever individuals might be, like you don't own that.
No, someone else could be there in
Right.
that
2
room.
days after you're
Yeah.
gone, or a day after you're gone, but
Yeah.
that there's a
That's
level of.
hospitality. And I do believe that
Right,
STRs
so you-
fall into this hospitality context.
Jake, you want to comment on that? You don't have to. Just trying to keep you engaged.
I concur with her. I mean, you look at things from the technological age. The desk person at a motel is now on your cell phone making your reservations. Your cleaning crew is coming before and after you leave. So yeah, I agree with it. There's a lot of similarities.
Okay, so the point is, what I'm hearing this discussion is moving away from a definition of motel that's tied to time, but but tied to a style of use.
Yes.
And if that definition meets there, so that's what we're trying to do. So effectively, the question is that a motel? And when someone rents out their house when they're no longer there, provides that service. The definition of commercial use includes the provision of services, not just products. So what that would do would be, of course, we don't have any, in the rural residential district, there's no explicit language like we had in Edelweiss, where it explicitly says no commercial use. However, the reality is
Well, we
that-
have an entire district designated for commercial use.
Right, and permitted uses are farms, buildings, structures associated with farming activity, woodlots, single-family houses, multiple housing, home occupations which are specifically defined, and then the list of special exceptions. So it's reasonably easy to exclude commercial use, from the rural residential district, particularly because the rural residential district, along with the Edelweiss district, where residences are those locations where the rural activity of, shall we say, living rurally. Okay, so if we were going to go that way, we need to identify those items which characterize the motel and which characterize, the rentals in short-term rental. So.
So the service, like, for example, offering the service of lodging, like, that's a motel, that's a short-term rental?
Yeah, so service of lodging,
I think what Jennifer was saying, the characteristics before, an expectation that someone is available to respond.
Yes, that you have a contact in case if you need something, so there's someone on call, shall we say, that there's an element of security. That can mean locking.
You have your own entrance.
You have your own entrance, you have somewhere to park your car, you have privacy, and you have,
Well, that's covered under the definition already by the independent
Yeah.
access, right?
yeah. Yeah, that's an ADU, accessory dwelling unit, actually.
yes. The only difference between an ADU and a bed and breakfast is that an ADU is a single
Yes,
item that is permitted to be rented out, but the assumption is that it's also owner occupied in the main residence. I could go away for a weekend, but the point is that,
That you live there.
that you live there, right? That might be on a trip, but that's,
Right.
yeah. Okay, so you have access, you have,
Parking.
so parking, you have basic support services such as cleaning. There's a lack of a rental agreement.
yeah. It's short term, actually.
So that would be 5 characteristics.
There's compensation. There's an exchange of
There
compensation.
is an exchange of money, yes. You're
Right.
paid to do it.
Compensation, yes, and the, that's actually that actually helps us, because if you have a rental agreement for a home and you're gonna stay there for a while, then you're not paying tax as a short-term rental.
Right.
There's no meal.
There's no meals and rooms tax,
tax
right,
attached.
for me renting my home out. Now, I don't know what happened, not having been in the business, I don't know what the minimum time frame is. Was it 6 months or 4 months or 3 months? I don't know.
It's not
It
really.
varies probably from state to state. But the bottom line is, what's that, Jake?
Could you just say that the property pays room and meals tax for each guest?
Yeah, so the compensation includes the obligation to pay room and
Okay.
meals tax would indicate that it's a motel,
Yes.
as opposed to, a home that's intended to be rented longer term, that's got a rental agreement and there's,
And a lease expense.
and that's, Okay, so we have 6 items that we can say are normally understood aspects of a motel, which includes providing the service of lodging for, we'll just say unspecified, but usually short time frame. There's some provision of basic.
Short's such a nebulous word. Do
Okay,
we
let's
want to
not do
stick to
that.
the transient piece?
Yeah,
that
just
it's
use
of
the
a
language
transient
that we
nature?
have. Yeah.
Okay, good.
That's standard, our industry standard language
Alrighty, okay. Lodging.
of a transient nature.
Of a transient, generally of a
We
transient
avoid that in
nature.
hospitality because it has another.
The word short term or?
No, transient.
You, I'm sorry, you.
Sorry, we avoid that word in hospitality per se, but it's
Well,
used,
but it's in our,
legally,
but it's in our
right.
zoning ordinance and that's
Absolutely,
right,
and
yeah.
we're using it in this room, the public are using it.
Okay, so it provides a service of lodging generally on a transient basis.
Mhm.
In exchange for compensation that includes meals and tax.
Yeah, okay, in exchange for compensation,
It
right?
doesn't include meals, it's the
It's the
tax.
meal-
It's
it's-
called, the tax is called meals and room
Oh, it's-
tax.
okay, so that's
Yeah,
in
it's a
there,
meals
yeah,
and
okay,
room
got
tax,
it,
yeah.
yeah.
Right.
Because you're not obliged to provide
No.
any,
Food.
anything, beverage, you don't even
No, and
have
then
a coffee
the-
machine.
Correct.
No, but the third one then would be some provision of basic support services,
Yes,
such as cleaning,
definitely,
um,
yeah, cleaning,
okay.
that would be an expectation.
Fourth one would be independent access. Fifth one would be parking.
Mhm.
Sixth one would be a lack of a rental contract, which would be one way for us to distinguish, for example, between the short-term transient use and someone who wants to come in for
A month, 2 months.
a month
3
or 2 months would generally have, a rental contract. Although it's hard to know exactly how those are, but that does give us 6 characteristics of what a motel is. If that matches the kind of definition that we have, so we have this definition that goes back to 2015, which predates the purchase of the house and its first rentals. The question then is, where we're headed at the moment is to say that those definitions with the uses that are described by them were already prohibited by the ordinance in 2015. Probably earlier. The trouble is we're going to have to deal with this depending on the various cases, case-by-case basis, the exact dates of purchase and rental and all that sort of stuff, because realistically speaking, we also have an obligation to provide the landowner the best opportunity at having the right to a established non-conforming use, if in fact that does exist. So, because we're here to balance the rights of the owner against the potential of a town ordinance applying regulations that may be unfair to the particular property. Right? So what we're saying in this case is that if we accept this definition of a motel, that we're moving towards saying that they do not have a right to, do you?
Yes.
Okay. Are we getting close to making a motion? Jake, how do you feel?
Yeah, I feel like we could definitely make a motion for what we've been talking about.
Okay, then what
I don't want to make it, but we could.
No, okay, well. Yeah, okay, so it's gonna take a second to formulate that.
Because.
Okay, so, just a second, so what we probably actually need to do is add to our findings of fact our understanding of the definition of a motel. Right?
Yes.
Because, I mean, we have to make, because in the end, we have to document the reason why, well, we're leaning obviously towards not granting a grandfathering clause on the basis of the fact that this is a motel usage which was already prohibited.
So we would
It's
be,
it's our train of thought being put on paper.
right.
Yeah,
But I would also suggest that not only do we need to add what we've just indicated to be the aspects or characteristics of a motel, we need to, in the findings of fact, link the actual use of the home that the homeowner's renting,
See if that,
and show those points where it would connect.
or not.
Like that the homeowner is actively renting it for compensation that includes the meals and use tax, those kinds of things.
Yeah, or the opposite, fine, you know, I mean, you
Or-
can look at it
right,
either
or
way
the
or find out
opposite.
what does not gel with
Right.
that definition, what may differ, I don't
Right.
know, I mean, it's.
Like it doesn't have a separate entrance and there is no parking or any of those
I mean,
kinds
I
of
think that's
things.
unlikely, but yeah, you know, I mean, we should look at the case with
Yeah.
specific relationship
right,
to
so
those
we
definitions.
have a definition,
Mhm.
then we need to make sure in our findings of fact that this particular case
Does or does not.
does not in fact meet
Yeah.
these criteria. Okay, yes. Okay, so I will make our 9th finding of fact, our understanding of a fuller definition,
And characteristics.
well, it's better, the characteristics of a motel. That's better, because definition is a very specific term in our, okay, so our understanding of the normal characteristics of a motel. Okay, so we have already listed those, and Kate, I'll make sure that you get the wording to help refine your minutes. Okay, so then the next step then, which would be the 10th finding of fact, would be to establish the fact that this particular property substantially meets the definition of a motel.
And you can put in because.
Yeah. So this is, 21 Haven Drive, is that what this is?
Yeah.
This also,
Road.
well, what I
Haven
do,
Road.
I'm sorry?
Haven Road.
Oh, yeah, Haven Road, yeah. So what this also does is it allows the potential of a request for a rehearing should the owner actually be able to prove that doesn't meet the characteristics that we've listed, then that's, you know, a grounds for a rehearing. Okay, so the first point was is service was lodging. Okay, so we've already established the fact that 60 nights a year approximately. The home was rented. Without the owner present.
And that's for compensation.
Yes, for compensation. With the obligation, whether they paid it or not is another question. I'm just benefit of the doubt they paid it.
It's
Okay,
billed.
because we're not.
It's
Not
billed,
our job.
yeah, as long as it's been billed,
Yeah, yeah.
doesn't matter if we
right.
get paid or not.
For compensation with the obligation. And it's important for us to say that, to pay the meals and rooms tax, because that establishes the non-rental
Yeah,
characteristic of the. Okay. too, so basic services. Were provided. You know, it's furnished,
Clean linen,
cleaned,
clean linens, yeah.
yeah. Probably some provision for garbage. Well, we don't have any.
You don't know, they could
we
take
don't-
their own.
Yeah, well, the thing is, we don't
Rural
have
living
any.
could argue that you have to take, carrying.
Yeah, well, we don't, but we also don't have any data on that,
Right.
so we have to be careful. It's,
No, but there is, we do know that the owner acted as a point of contact for
mhm,
individuals.
Yeah,
right, and the
gotta have
owner,
a point of contact.
right, act as a point of contact. Okay, then we have, well, there was individual access and parking provided, and,
In this particular case,
and
yeah.
there's no rental contract. Now, of course, if they, have a rental contract that specifies, we get to represent no rental contract, other than, other than for the,
Duration, the short duration.
yeah, the services.
The transient
Transient.
Of
duration.
a transient, the transient services of transient nature. Okay, so,
With 6, and that was 5, didn't we?
1, 2, 3, 4,
Doesn't have to meet on 6, I'm just saying.
just hold on a second. We actually had 6, okay, so, okay, so no, actually the first one, for compensation, that's actually 2.
We found that into 2.
Right, so basic we provided, that's, so what are we missing? Parking, lack of a rental
No,
contract,
it's a-
compensation.
Lodging was 1, compensation was 2, basic services 3, point of contact 4, individual access and parking 5.
So you made access and parking a
Oh.
single one? They need to, are they 2?
Yeah, there are 2.
There you
Yeah,
go.
there's our
That's
6.
it.
Yeah. C, D, E, and F. Okay, so okay,
And
so,
no rental contact. 7, actually.
okay, so then, all right, I'll take a stab at suggesting a wording. To deny the appeal because the home was, okay, well, we actually have to answer one of the other, well, okay, point 1, they, well, because they asked that they had the right to rent because of the homeowners association. So, because,
Town ordinances supersede homeowners
well,
association.
yeah, but actually, because no pre-existing non-conforming
Rentals.
use was established before the HOA, what do they call that thing? HOA charter? Was restricted by the Madison zoning ordinance. Ordinance, effective for this house in March of 2015. For the record, the house was purchased in October, November, right? What's that?
December of 22.
Yeah, close in December.
No.
No.
The Davises,
Oh, yeah, sorry. Oh, never mind.
yeah. No, because this particular statement is established in the fact that it didn't have a pre-existing non-conforming use in 2015 when it was sold the first time. Okay, and then secondly, because the rental usage meets the characteristics of a motel, which is not a permitted use.
Motel by definition of our,
I'm sorry.
is it motel by our definition or?
I would say what it says meets the
Well, what I said.
characteristics of a motel as indicated in the findings of fact.
Right.
Because those
Right,
characteristics are
as
the ones that we
indicated,
use.
right, as indicated in the findings of fact.
And is not a permitted use.
Yeah. And which is not a permitted use. Okay, so what we have here is we move to deny the appeal because the home let's see. Just a second, I'm just too much scribbling here, just let me smooth out the language. Had no pre-existing non-conforming use before, oh, no, oh, okay, that's it. Because the home, just a minute, I've used too many verbs here, just a second. Because the home,
Do you want me to read what I have?
yeah, go ahead and read what
Okay,
you have.
So you tell me if this is not, doesn't work. Denied appeal because the home had no pre-existing non-conforming use, which was established before the homeowner association charter, was restricted by the Madison zoning ordinance effective for this home in March of 2015. And then your next one was because the rental usage meets the characteristics of a motel as indicated in the findings of fact, which is not a permitted use.
Okay, I
Got it?
think part 2 is fine. Reread
one.
part
You
1.
reread
Yeah.
part one.
One,
Yeah, because the home.
deny the appeal because the home had no pre-existing non-conforming use. Right?
Period. Is that a period? That's what I'm
I
asking.
can put one there, whatever you want me, but then he talked about being established before the homeowner association
You know,
Or
yeah,
put it
yeah,
in.
just a second, we can make this a little,
Yeah,
because the
make it
home
smooth.
had not established a pre-existing non-conforming use under the HOA charter,
Yep. Which was restricted by
before it was restricted.
it was restricted by the Madison zoning ordinance effective
March of 2015.
for this, yeah, I think of the house, the house part.
Yeah, okay, so why don't you read the whole thing again?
Okay, bear with me. My scribble is just like yours. Denied appeal because the home had not established a pre-existing non-conforming use under the homeowners association charter.
Of 1976.
Oh, we didn't have that, 1976. Before it was restricted by the Madison zoning ordinance effective in March of 2015.
Yeah,
That's
that's
a
good.
mouthful.
Yeah, and then 2, go ahead and read that again.
Because the rental usage meets the characteristics of a motel as indicated in the findings of fact, which is not a permitted use.
Okay, so as chair, I'm allowed to move that. Do I have a second?
Oh,
Second.
hold on,
Yeah.
okay. Roll call.
Okay, we'll start with Sharon. Well, hang on a second. We're gonna call the vote. Is there any further discussion, Jake?
No.
Jennifer, any further discussion? Okay. All right, Sharon? Okay, so,
I means I vote to deny.
correct.
Mhm.
You're supporting
Thank you.
the
Yes, so I am eyeing.
aye. Jake?
Aye.
Jennifer?
Aye.
Okay, so we unanimously decide to deny the appeal. And the way it's written does give you the opportunity to provide data that would contradict our assessment. Let me just read this. If anyone wishes to appeal, one must act within 30 days of the date of this notice, day one being tomorrow. The necessary first step before any appeal may be taken to a higher court is to apply to the Board of Adjustment for a rehearing. The motion for rehearing must set forth the grounds on which to base the appeal. Board members are advised to refrain from discussion of the appeal with other board members and any other parties to the appeal until all further appeal periods have expired. Thank you. That closes case 2315. Okay, so we will now take 2318, which is somewhat similar. Okay, Jake, you still there?
Still here.
Okay. So, because I'm elevating Jennifer to voting status on this case as well, would you read the notices, Kate, so we...
Case 2318 continued October 18th, 23, November 15th, 23, January 17th, 24, February 21st, 24, March 20th, 24, and April 17th, 2024. April from administrative decision from Matt Johnson, Esquire, Divine Mill Branch, PA, for agent for Matthew Petty and Jennifer Swift, that was Skyline Way, tax map 205, lot 48, to determine whether or not their circumstance allows for short-term rentals relating to a denial from Robert Boyd, Code Enforcement Officer, dated August 16, 2023, as to Article 4, Section 4.2 of the Madison zoning ordinance. And everything, let's see, that's these. So everything was posted on April 24th.
Okay, so Jennifer, do you have conflict of interest with this case?
I do not.
Okay, Jake, you've already responded, you have not here. Sharon, you have said no, and I have said no. I believe this case also technically had a waiver because dimensions,
Waiver request was accepted.
yes. Dimensional issues are not an issue here, so, and there's no regional impact. So, I will review the preliminary findings of fact in a summary fashion and then let Mr. Johnson address the issue. The date of the purchase of this particular home was April of 2023. The first rental by the current owners was in June of 2023. There is documentation that proves the regular rental of this home from February 2021. So there's no dispute of the fact that if short-term rentals were permitted, that there is a claim to be grandfathered. There was no lapse of rental activity in the time frame back to 2021. A summary of the selective level of activity was 32 rentals for 157 days in 2021, 27 rentals for 103 days in 2023. 2022 and 2024 were not estimated in the meeting. The current owners anticipate renting something on the order of approximately 100 days per year. The home is in Skyline Estates Owners Association, and there is no mention of rental in the deed restrictions for that homeowners association. The home was built in 2018. The first documented rental was in 2021. That is, so the request is to have a pre-existing, to recognize a pre-existing non-conforming use based on the March 2022 date of the change of the Madison zoning ordinance. So we have a similar situation here. Is the March 2022 date the critical date, or is an earlier date a critical date? Mr. Johnson, do you wish to say anything?
I continue to say that, with all due respect, the ZBA is getting their analysis wrong. It is the March 22 date, and it's not that. I would draw your attention to the code enforcement officer's enforcement actions and notice and cease and desist, and it all refers to the fact that with the change in the ordinance, it clarified that they're not a single-family dwelling. There's never been an enforcement action, to my knowledge, ever initiated over the thought that these are actually qualified as motels. I think that's an erroneous interpretation by the ZBA, which made it in the last case, and so I don't think, factually, I think this case presents the same way as the prior case. It's obviously up to the ZBA board to make their decision however they wish. I reiterate the fact that I don't think you're doing it right. I think the ordinance changed March of 2022. If the short-term rentals are barred by motels, make 2 points, by the motel definition, make 2 points. Why was there never any enforcement action initiated by the town until the March 22 zoning ordinance change? And the other proposition of statutory construction, if in fact short-term rentals were barred by the motel definition going back to 2015, why was there any need to amend the ordinance to add the transient definition and add the transient limitation to the dwelling unit definition, which came in 2022? And from my position, that's proof that that was when the change happened and not back in 2015 or earlier, as the ZBA believes it is based on their prior rulings. So.
Does anybody from the public wish to speak to this case that hasn't been sworn in? And we don't need to repeat arguments that have been already made. Okay, I mean, if your arguments are the same for this case, I mean, if you wish to simply say I would like to reaffirm that argument, that's okay. But I don't want to. I'd like to move this along.
Just want to.
Sure, go ahead.
Can I just stay here?
Yes, come up and state your name.
Okay. Burley 5 Lakeview Drive. Far as he says they're not a problem, and why didn't the town do something about it? What happens is, the only time the town doesn't go around, or the building inspector doesn't go around policing. Once something's been brought forward that's a problem in the town by anyone that's upset with it, and the ordinance is existing, that's when it gets to be brought out. Not only that, even if the ordinance exists and was never used, it doesn't matter, because at any time the problem starts, it can be used. And this all is very simple. I'm just going to go back to the motel thing. Being a builder for 45 years, I don't care what town I went into, if it was a residential use area, they would not allow me to build a motel or anything that is like a short-term rental, because it is a motel. It's the same thing. You have people going in and out constantly, daily, by day, they pay by the night. They have room service, and they have everything else that goes along with it. And again, no town, city would ever let me go into a residential zone and do that. And it's up to the people, when they buy a property, to know the ordinances. It's not up to the town to go create problems for them. And when it's brought up to them, that from a local, that it needs to be addressed, it needs to be addressed. Thank you.
Mr. Cancellara.
Yeah. Did you wish to? I'd ask you to be brief. We don't need a complete recitation of.
If you're making an assumption there, John Cancellara, Chippewa Rose, but I have a house here. I do want to submit this for this case, the information. I do want to include, like, I know you put facts in there. One of the facts that I'd like to be put in for this one is the fact that there is a sort of rental being done on special exception. That was not kind of mentioned in your facts, and that one is an owner occupied. And it is important to say that when you allow one, it restricts all the other ones, because it could have been put in there.
I'm missing.
The point of
Go
what I'm
back.
saying.
Yeah, there's
Okay.
one.
So I know
that
you
was a
mentioned,
special exception.
I know you mentioned how if, in your previous case, you're saying, oh, it's very similar to motels. Motels are not mentioned in here, that's correct, because we're permissive only. But also, if it was allowed, it would have to be owner occupied, it would have to be a bed and breakfast.
Oh, yeah.
That's my point that I was trying to make on that.
Oh, I see.
So I'd like to submit this again. I won't repeat things for that. The second part is on his narrative. His narrative's not correct. He's creating a narrative that doesn't exist in our town. We did go after people beforehand, before the 2022. Also, what happened during that time too is the planning board actually tried to create an ordinance to have short-term rentals. And the town voted, and how the town voted chose. That's what happened with the town ordinance. It was not the first time we went after people, but they stopped going after because the planning board was creating an ordinance and wanted to see what happens with the town. So his narrative is not correct on this is the first time that the selectmen have ever gone after anyone.
Okay. No, you,
It's the same thing you had in the other case.
yeah, that's fine. Yeah.
We just want to close the file.
Okay, so Jake, just to confirm, you're still there.
Still here, heard everything.
Okay. Okay.
There's one more.
Yes, we have somebody else who wishes to speak, Mr. McKenna.
Paul McKenna, Edelweiss. I'd like to just say what Mr. Johnson said is false, that there are no problems. I can furnish police reports, numerous police reports from the STR beside me. I also know that the chief of police sent them a warning stating that if it continued, they were going to be fined. Thank you.
Them meaning the owners, or?
The owners. Thank you.
Yeah, just for the record, while the board acknowledges that some of the STRs have had numerous complaints, what this board is examining is not whether there have been problems with the experience of the STRs, but whether or not the underlying ordinance permits them. So we're not an enforcement issue, we're actually kind of the lowest level of court trying to decide what the law says, as opposed to trying to determine based on the experience of what those things are. So while we do appreciate the fact that they have been a problem, those problems have been a driver for, you know, some of the warrant articles that have been passed, et cetera, et cetera. So what we have to do as a board is decide to what extent this case overlaps similar decisions that we've made up to this point. And we are obligated to act fairly consistently, but the unique characteristics of each case may give us grounds to give a different decision because the applicability of the situation. So that's what we have to debate. So, Jake, do you have any questions for anyone in the audience?
No questions.
Jennifer, do you have any other questions?
No, I do not.
Do you, Sharon?
I do not.
Okay. Can I,
Can
yes,
I-
Mr. Johnson.
Two
sure.
quick comments, and
Yes.
then I'll be done.
Yes.
One, just to play off the comment, I think it was in a prior hearing, but I would submit that the average person looking to buy a property and looking at the Madison zoning ordinance and looking at the definition of motel would not consider that the ability to rent their own family house on a short-term basis fell within that definition. And so I think there is an inherent ambiguity there, and then that raises the administrative clause doctrine, which is to the extent that that has not been interpreted in a way that you guys are now, then that's inconsistent with prior performance. And with that, I will tend to the floor.
Mhm. Okay, can I entertain a motion to close the public hearing?
So moved.
So moved. Second?
Second.
Okay, Jennifer second, Sharon, okay. We have to vote by, yeah, roll call.
Aye.
Aye. Jake?
Aye.
Aye.
Okay, so the public hearing is closed. Okay, so we are there characteristics of this particular request that radically differ or insignificantly differ from a previous case that would require a completely new analysis?
No.
I don't think so either.
Okay, so if, we'll take a look at this a little bit more detail. But what that means is that in order for us to be consistent with the previous decisions that we've made, that we would be saying that the ordinance that existed in this case, 2000,
It's still 2015, you can still use. the same
right,
one.
yeah, so but the point is that this house was first rented in 2018.
2021, it was first
I'm
rented
sorry,
in
rented in
2021.
21, it was
Built
built in
22.
2018. Yeah, so we're on the same basic, we don't have to research back, into the details of earlier ordinances to see if we are running into difficulty with the terminology. So what this would mean is that effectively, we could take the same argument exactly. Now, the only other thing that we haven't done, we didn't do it with the last case. We had agreed earlier, I believe as early as November, that we wouldn't need to rehash all of the legal arguments that Mr. Johnson had put forward. Now, in earlier cases, we have addressed them at least once every evening. So probably to be fair, while the board is well aware of those arguments, as we made our decision in the last case, I think it's fair to consider those arguments so that they're a part of our record. And I believe we can perhaps bring our response to those arguments forward from the minutes of, let me see, did we have a,
Here.
Yeah, we have
We'll have last month's.
last
I have
month's minutes, right.
redlined in areas, but we'll
Right,
get to that
okay.
later.
So I will just. When did
Are we
we?
in there?
Yeah, we, right, these are his legal points.
Right.
Did we? Well, what I wanted to do was get our response. Yeah. No.
Don't know what's in there.
Speak already, I'm not sure we did. I thought we did last month, we. No, just a minute. All right, well, I'm looking for a simple bringing forward however.
ZBA minutes.
Oh, okay. Just a second. So, the one, okay, the first point of his analysis, which we're addressing is a pre-existing non-conforming use in a little bit more detail, so I'm not gonna go over that one. The second, the amended dwelling unit definition upon the code enforcement officer is relying on an unconstitutional because of its vagueness, ambiguity, and or overbreadth. The third point, which I would take with the second one, is that the amended Madison zoning ordinance violates the substantive due process rights of the owners and creates a regulatory taking under the New Hampshire and federal Constitution. Our response to those two things in the previous meetings was effectively that the RSA, don't have the notes in front of me, I think it's 674-19, specifically 16, grants the town's legislative body the right to regulate land and building use. Oh, in fact, that is our response, is it not? Yes.
I believe so.
Um,
They may have had some.
Yeah. Anyway, so we do have the right to regulate land usage. This board does not do that. It's the legislative body of the town which writes the ordinance, which is one of the reasons why ordinances can be, shall we say, from the perspective of wording, quite challenging at times, because there are warrant articles and counter warrant articles, and some are passed and some aren't passed. And so sometimes there are holes in the ordinances, and so that's what makes it particularly challenging. It's not like a consistent congressional body that actually works on the definitions. So, but the town legislative body does have the right, it's not a regulatory taking. The amended Madison zoning ordinance violates the owner's equal protection rights. The amended zoning ordinance affects property so to subject to the immediate level scrutiny. Madison cannot show that the amended ordinance is substantially related to an important governmental objective. And we countered that by simply saying that, well, in fact, the point of the ordinance was to promote the town's purpose in promoting the rural living and to minimize the use of what was intended to be family housing for transient use. That is the point of, the purpose, as Sharon pointed out earlier. And fifth, the amended Madison zoning violates a particular court case here, Britain versus the town of Chester. In the Supreme Court struck a zoning ordinance that acted to restrict access to affordable housing. And we felt that this particular objection was not relevant to the case because short-term rentals don't restrict in any way, shape, or form access to affordable housing. In fact, they make it more complicated to get affordable housing rather than the ordinance making it more difficult. So that's a very brief response to those particular legal points that were advanced before, and they are a matter of record of our previous meetings as well, so we're going to be consistent on those points. So we needed to focus on the specific question raised in the first one, which was the question of grandfathering and whether or not we can then effectively bring forward the same decision we had on the previous case. Jake, do you want to respond to that, just so you have a chance to get first out of the...
I believe it falls under the same 2015 is that time. This house was built in 2018, therefore I don't think it's grandfathered.
Okay, Sharon, did you want to say something?
I just wanted to let Kate know that what he was reading from were the March 2024 minutes, so you can go back and find it. And
Well, no, actually, what I was reading from was the letter from Matt Johnson.
He was reading the legal analysis and the factual background.
Right, I did refer to the March minutes
20.
in order to get the RSA correct.
Yeah.
Yes. Mhm.
But I also agree that specifically with regard to the timing of purchase, rental, previous rental, existing non-conforming use, any of those types of chronological, I don't want to call them wickets, but the pieces that you would need to establish, none of that what is established here, all of it is post the purchase and starting to rent it in 2021, we said? So
Yeah, February 2021.
yeah, February 2021. So I don't believe that this is substantially different than the case before.
Sorry, so you're arguing that it's not substantially different.
Different than 2313. 15, sorry.
Yeah.
Okay.
So, okay, it's not substantially different because we have a date where the rental is recent,
Yeah.
and even though it predates 2022, we're dealing with exactly the same
Set
question.
of circumstances.
Well, we can just bring forward those final findings of fact regarding, can add to this. A second, let me get Okay, so we have the preliminary findings of fact. So in this case, then, number 8, 7 was the home was built in 2018. First documented rental was 2021. So then we have the same number 8 in this case would be basically we pick up at number 9 from the previous case that on the what do we say?
The characteristics.
Characteristics of a motel. Then we list the 6 characteristics of a motel. And then number 9 in this case then lists the reason why we believe this particular case, and this is worth being more explicit, not just simply bringing that forward, because we are obligated to consider each case. This is a documented rental, that began in 2021. And we'll just say for the sake of argument, that's 100 days and a few more per year, which were for compensation with the obligation to pay meals and room tax. Basic services were provided, such as cleaning, the owners acting as an agent, or in this case, probably had Airbnb, I can't remember. Do we have that as part of the record?
I believe it was in that packet they provided.
Yes, just a second, we're looking that up.
This one. Airbnb.
Yeah,
History from
Airbnb.
Airbnb.
Yeah, so there was an agent acting for the purpose of providing short-term rental. So, what were the next two? I can't read my writing here.
Let me see. I can. Independent
Oh,
access
yeah,
and
independent,
parking.
yeah, independent access and parking. Good, thank you, Sharon.
You're welcome.
And there was no rental contract with the intention of renting anything other than on a transient basis. The board feels so inclined that we can take the same motion from the previous case. Before we do that, Jake or Jennifer or Sharon, do you wish to amend or change the summary statements we just mentioned on why this case meets the definition of a motel?
I have nothing further to add.
Okay.
I just wanted to clarify, we did also mention that in this case, the HOA documents do not have any reference to rentals. And in the previous case, we
No,
did
there-
mention that the town ordinance superseded the HOA.
Right, they were silent on the issue of
Yeah.
rental. Right,
You want to
so-
put that in the findings of fact?
But that is a part of the finding
I
of
think it
fact.
might already be,
Yes.
I'm sorry if I'm,
Yeah.
I just noticed
yes.
that one is one significant
Number
difference in
6.
general.
Yes.
Okay, so
Number
that
6,
is
the
on
home
the-
is in the Skyline Estates Owners Association, and there is no mention of rentals in the deed restrictions.
Right, okay.
Which,
I guess it's like a,
but because those are deed restrictions and there's no mention of
Right.
rentals, that would imply that there's.
was a yay or a nay, yeah.
Yeah,
absolutely,
right.
yeah.
Mhm.
So no, I have no wish to amend.
Okay. Someone wish to move that we, identical motion?
I move that we make the same motion as we made in the previous case, that we move to deny. And then you're gonna write out all of
The
it?
whole thing.
Okay.
Right, and
Do I
why
need
don't
to
you,
read
okay,
it?
but yes, let's read it out loud
Read
for
it.
the record. And are you so moving?
I so move.
Okay, let's,
Wait a second.
yeah,
Are you
no,
gonna
no, read it
Read it
first,
first.
read it
Let
first.
me get to it. Hold on. Okay, I gotta go back to here. Okay. Deny the appeal because the home
Oh, that
had
part, so
not
we can't do it.
established, what?
I don't think we can do the same exact.
Okay,
because
no, that's
that
why we're
talks to
reading
the
it, so let's
HOA.
go ahead
I'm
and,
just gonna read it out loud.
yeah, let's
Because
adjust
the
it.
home had not established a pre-existing non-conforming use. And you can't use it because they're under the HOA charter
Right,
of 1976.
no, right, we can't do
So
that.
you need to
I
read.
knew there was a reason.
Okay, but, okay, take that paragraph out, because that, we didn't have to address that, because that's not an issue here.
Okay, so.
Well, I do still think that we need to add that it did not
Mhm.
establish a pre-existing non-conforming
Okay.
use.
Let me write that in.
Okay, so in this case, then let's be specific, under the Madison zoning ordinance of,
2015.
Under, was restricted by the Madison zoning ordinance effective in March of 2015.
okay,
And then
Well,
because the
yeah.
rental usage meets the characteristics as indicated in the findings of fact, which is not a permitted use.
Characteristics of a motel,
Sorry.
as indicated in the findings of
Yeah,
fact, and is
which
not a
is
permitted use.
use.
Okay.
Okay, I think we need to go back to that first one.
Clean that up.
Because it's not just 2015, there's also 2018 and 22. Because they're all consistent, but we can't,
We can say as first established in 2000, or I don't know that it
well,
was
that's
first
just it,
established in
yeah,
2015.
I think we need to rework this one on this one.
Yeah, that's okay,
Yeah.
that's what we need to do.
So I need to withdraw my motion at the moment, since we didn't really have a full one,
All righty.
and let's work on that.
Okay.
So, the home did not establish any
So, Kate, when you've gotten far enough, then read it back to us.
pre-existing.
You didn't change anything.
Oh, I thought you were erasing pieces there.
No, I'm crossing out so I don't do that in this motion.
Okay,
It's getting
all
very
right.
confusing now. So I can read what we did in the other
Just say-
previous motion, if you want me to read that again.
Just 1 second.
I-
Sharon's word
I'm
smithing.
scratching.
Okay, you scratch.
The home did not establish any rental history use prior to 2021.
Short-term rental,
Short-term rental use
because we don't know.
for
maybe
transient.
Transient labor.
Transient rental history prior to 2021.
February 2021.
February, yeah.
Mhm.
Which wait, did not establish any transient rental history prior to February of 2021, which then what's the piece that you wanted to say about the 2020, the 2015, 2018, 2022? Which does not,
Yeah, well, in this case, the 2018 ordinance is early enough. What was this, which does not?
which then does not, so it says, the home did not establish any transient rental history prior to February of 2021, which then does not predate the existing zoning ordinances from 2018 that did not allow motels in
Which was not a permitted use.
rural, or which is not an
Not permitted
approved,
use. We're gonna read this out loud when you're done.
which
Got it.
is not an approved use and is therefore did not hotels as an okay. Let's start with this and see where we need to go. The home did not establish any transient rental history prior to February 2021, which then does not predate the existing zoning ordinances for 2018. That did not allow motels as an approved use in rural residential districts.
Okay.
I don't know if that makes sense.
The grammar is a bit clunky, but
Yeah,
Isn't it?
It's not flowing nice for me, but
Well, but one of the things we haven't said there was, which we did say in the other one, was that we established the characteristics.
Yeah, I think that's still B. I think we keep that as
Oh,
B.
you're still
This
just
is,
working
I'm
on,
just,
you're
I'm
just
working on
A.
A.
Okay,
I'm
fine.
working on the A part.
Okay,
But I
fine.
think I think the B part is fine to
B part
carry
was
over.
because the rental usage, rental usage meets the characteristics of a motel, which as indicated in findings of fact, which is not a permitted use.
Why don't
Okay,
we make that A
okay.
and then make this
All right,
B?
well,
If you make that A, because you're addressing the characteristics and you're establishing
Right.
it as similar to a motel, then, and then in B, where it says it did not establish any transient rental history prior to the February 2021, prior to February 2021, and which then does not predate existing zoning ordinances for 2018 that did not allow motels as an approved use in rural residential districts.
The only thing about flipping them is what is now A is actually general, whereas and B is specific to this case, it's this property. And I think we should
Well-
lead with the specific to this property,
Well, this
rather
is,
than the general definition of a motel.
right, but this isn't the general definition of a motel. This is just indicating that the ordinances didn't authorize,
Okay,
didn't allow motels in
so you're starting
the
with a general
ordinances.
statement and then focusing on
Well-
this particular address.
This specific statement says that this home did not
Yeah.
establish any transient rental history
Right.
prior to
No,
February
no, I
2021.
know that, but you're putting that as the second paragraph, as B, rather than as the first paragraph.
Correct.
Which is fine, yeah, I'm just asking.
Mhm.
General to specific rather than specific address, because you can put the address, when you say this home, I assume that means this
yeah.
exact address, 70
Yeah.
Skyline.
Okay, so which way you want it, Sharon?
It's up to you.
I think either way, as long as whatever way makes sense from a, because I do still think this piece is clunky.
Let's hear what Kate has and then we'll
well, I
wordsmith
didn't
and
get
see.
all of what she said.
Sorry.
This
Okay,
is,
well, that's part of the game. Okay. You want to take one more stab at it, Sharon?
You've got
So-
which then, you could
so
put
A is gonna
consequently.
be, because the rental history usage meets the characteristics, meets the characteristics of a motel as indicated in the findings of fact, which is not a permitted use, so that's your A. That makes sense. B, you gotta work on.
Right, B being, the home did not establish any transient rental history prior to
History.
2021.
Full stop.
History.
Any
prior to
transient rental
February
history,
2021.
February 2021,
Full stop.
What?
That's a period.
Full
That's-
stop.
Yeah,
Yeah.
period, okay.
sorry, wrong language.
Then how do we get into this? We're trying to work in not work in, but indicate that the 2018,
Consequently, you could put comma and not full stop and then put consequently does not.
the 2018 ordinances,
2018 ordinance, yeah.
yeah, the existing zoning ordinances for 2018 that did not allow motels as an approved use in rural residential districts.
What was that? Allow?
Did not allow motels as an approved use in rural residential district. There's nothing in here about then, they have not established any pre-existing non-conforming use.
No, there isn't, we're missing that.
That was at the beginning of A.
Right. The home did not establish any transient rental history prior to February of 2024, therefore
21.
not establishing any,
Therefore,
yep, therefore, consequently, not establishing any pre-existing non-conforming use.
yes.
In accordance with the 2018
Mm-hmm.
zoning ordinances. And I think you can say put period there, because I don't think you need to repeat that motel piece, because it's in the second,
Mm-hmm.
in the other paragraph, I should say.
So we're still keeping A as it was. Right?
You want to
No,
flip this
no,
back
no.
to A?
Mm-hmm. No, if you don't want to, I was just putting it out there.
Because you originally have A, because the rental usage meets the characteristics of a motel as indicated in the findings of fact, which is not a permitted use.
Can't start a sentence with because, you certainly can't start a
Wait, you
statement
have-
with because.
Well, no, the
Well-
sentence starts as we move to deny the appeal because.
Because.
Okay.
Yeah,
Right. So you're gonna keep that one first?
What do you want to put this one?
no, let's do the other one first.
Okay,
Yeah, let's do
So
this one
do it-
first.
this one, okay, so he
Yeah.
wants to use this one, that the home did not establish any
Hold on.
transit.
Hold on, I gotta. Okay. Not establish any transient use. Rental history. Go
Transient
into
rental history, yep,
Transient rental.
Prior to February of
2021.
2021.
Therefore,
Not,
not confirming or
Forward.
establishing any pre-existing non-conforming use.
establishing, take that out. Any pre-existing non-conforming use,
Rental use or short-term rental use,
STR.
Yes.
Ow.
okay? Does that make sense? You wanna read it out loud?
It's like chicken scratch.
I
Because we
know,
changed it like so many times. Okay. That the home did not establish any transient rental history.
well, I'm gonna stop. We should change home to owner,
All right.
because the home can't actually do anything.
Right.
It's a structure.
That the owner did not establish any transient rental history prior to February 2021, therefore, not establishing any pre-existing non-conforming STR use.
Period. There you go.
Wow. I think that's the worst one. Yeah.
I know, sorry.
That's all right, no, it's not you, it's just me trying to get it. Makes sense.
So can we get the whole thing then?
How many times? 10 times? All right, so we're making
A
A,
motion to deny because,
we're doing A, now we've switched it, right?
right, it should start with the owner.
Okay, that's what I have, that the owner did not establish any transient rental history prior to February of 2021, period. Therefore, not establishing any pre-existing non-conforming short-term rental use. That's it.
And?
And then
That's it.
B, yeah, that's it
Yeah,
for that
B.
part. Then
And then
B,
B, because the rental usage meets the characteristics of a motel as indicated in the findings of fact, which is not a permitted use.
We don't have anything about dates in the ordinance.
no, in 2018, we have the
Oh,
2018.
Okay.
No, you didn't,
Hmm.
you didn't put 2018 in.
Oh.
No, you took that out. That was originally in B, which now became A.
Yeah, because we have that, I hate to say it, but the relevance of 2021 is only.
Is based on
Is based on
2018.
the fact that it's 2018.
Yes. Okay, so the owner did not establish.
Actually, maybe it makes more sense. Read B again.
Because the rental usage meets the characteristics of a motel as indicated in the findings of fact.
And, hold it right there.
Mhm.
And as defined in the ordinance,
2018, yeah.
yeah, 2018.
In the Madison zoning ordinance, 2018,
Yeah.
which is not a permitted use. Period.
Right, okay, then it doesn't make sense to put the
Right.
second, what's currently paragraph A, secondly.
Mhm.
So,
That's paragraph B.
yes, but what we're saying is let's swap them back. Put B as A and A as B.
Matters.
Oh my God.
I'm sorry.
That's okay. So now I'm going back to A. All right, we're gonna do this again. So A, you're denying the appeal because the rental usage as defined in the Madison zoning ordinance of 2018 meets the characteristics of a motel as indicated in the findings of fact, which is not a permitted use. All right, so that's A. B, that the owner did not establish any transient rental history prior to February of 2021, therefore not establishing any pre-existing non-conforming short-term rental use.
Yep.
We have-
So
I
moved.
just- All right, so you made that motion.
Yes. Who's gonna second?
I'll
Did
second.
Jake hear everything?
I'll second.
We'll just check it.
Okay, any further discussion? Jennifer, Jake?
No.
No,
Okay, then let's vote. We'll start with Sharon.
Aye.
Drew, aye. Jake? Jennifer?
aye.
Okay. All right. Excuse me. Too many papers here. Where's my little
Cheat sheet?
cheat sheet? That's all right, just a second. I got one right here. Okay, if one wishes to appeal, one must act within 30 days of the date of this notice, day one being tomorrow. The necessary first step before any appeal may be taken to a higher court is to appeal to the Zoning Board of Adjustment for rehearing. The motion for rehearing must set forth the grounds on which to base the appeal. Board members are advised to refrain from any discussion of the appeal with other board members or parties to the appeal until all appeal periods have expired. Thank you. We will consider now the question of whether or not to rehear case 2313. This is a public meeting, there is no hearing, so this is a board deliberation only. I am elevating Jennifer to a voting position. Jake, you're still there, just to confirm that, please.
Confirmed.
Okay, so what we're doing in this particular situation is we've received a letter from Mr. Matt Johnson stating reasons why he wishes us to why he wishes to appeal the case. I'd like to say this as general information for the board. The board may, on its own initiative, without reference to Mr. Johnson's arguments, decide that we made a mistake. If that's the case, we may decide, independent of his arguments, to rehear the case. Okay? So that's one thing. Now, Mr. Johnson's arguments, generally speaking, in order to rehear a case, there should be either something like a new information that could not have reasonably been known at the time presented, or he could make a case that we actually had a procedural error. For example, we left out an entire argument or something like that that should have been considered, in which case there would be grounds for us to rehear. Typically, grounds for rehearing that are inadequate is someone disagrees with our decision. That in and of itself is not an adequate ground to rehear the case, right? So either we have to agree with Mr. Johnson that there's new information that needs to be considered, or there's some procedural error that we've committed, or independently we may recognize that we made a mistake. Okay? So that's what we're doing. I would simply like to summarize at the beginning of this, and then board members, including Jake, you may stop me at any point here. I've got 5 observations to respond to Mr. Johnson's letter, and you can either listen to all 5 of them. It's only 60 or 70 words, and then, or you can stop me in the middle, okay? I would simply observe that Mr. Johnson did not provide new information that wasn't already known. There was no new information that I noticed. Now, you may disagree with me, but that I didn't see any new information. All right, secondly, Mr. Johnson has provided, but he has alleged several errors, okay? One is that the basis date for grandfathering being set in 1990 is an error because of missing definitions, page 3. My response to that is we actually used different definitions than he referred to in his arguments. He alleged that Conway versus Kudrick defines an STR as a residential and not a commercial usage. We took the stance that Conway versus Kudrick does not apply the definition of a residential usage uniformly to all things in New Hampshire, but rather refers the wording of the local ordinance as the primary consideration there, so that, as they stated explicitly in the court case, one might come to a different conclusion in a different city. He alleged that the motel does not apply because it refers to multiple buildings. On page 5, this is, but the definition itself clearly states that it can be a single building. He then rehashes his legal arguments on pages 5 to 7 and states that we did not address them. However, we did explicitly address the same set of arguments 30 minutes prior to this case in the other case he presented, the responses to which are part of the minutes. And we did agree in November that we wouldn't have to continually rehash all of those arguments in every single case in any detail. But we did address them the same evening, and they are part of the minutes. He alleges that we failed to provide a factual basis for our decision, but there are 8 findings of fact listed in the minutes and in the decision letter. And in particular, point 5 explicitly details the ground for denying the appeal. So that's my short response. And board members, please feel free to say there's a ground you think we need to rehear this case.
I do not.
Jake?
I do not.
Jennifer, do you have an opinion?
I do not have an opinion.
No, so that's fine. Oh, that's okay. Jake or anyone, as I listed those items, did anyone find anything that was inadequate, shall we say, to explain, to be a response to the...
No, I agree with your 1, 2, 3, 4, 5 different points. I did not, in reading through this, find any new evidence that we had not considered previously. And I also did not find any errors in law. I find that the Attorney Johnson disagrees with our decision, but that is not necessarily, it's not a reason to grant a rehearing.
Okay, the primary, I would say, one thing we do have to agree on is that a primary reason why, well, a case could be made if we had not made a stated a factual basis for our decision. I believe I have a copy. I thought I had a copy of the decision letter printed out here, which I must have accidentally put in. You have the decision letter? Sorry.
I just get it back.
Oh, yeah, no. Okay, so I'll read the decision letter so that you can determine whether or not any of you feel that this was inadequate, okay? Case 2313, continued October 18th, et cetera, et cetera. Findings of fact. The Madison zoning ordinance was updated in March 2022, defining a dwelling unit as one or more rooms arranged, designed, or used for non-transient residential purposes with independent sanitary and cooking facilities, and defining transient occupancy as a period of time up to and including 30 days. 2, there is solid evidence presented that the house has been in continuous use as a short-term rental since July 2017. 3, there was no lapse in the usage as a result of the sale or purchase. The relevance of the March 2022 date as a baseline to determine potential grandfathering is contested by abutters and residents. The language of Article 4.6 of the Madison zoning ordinance, which presumably goes back to 1990 and is attested in the 2015 version of the Madison zoning ordinance, which predates the first rental. Supported by the definition of the Madison zoning ordinance of motel, commercial use, and the normal understanding of business as defined by Webster Dictionary do not permit short-term rentals. The original owner, 6, the original owner of the home testified in writing that he built the home in 1985 and sold it in 2015 without ever having rented it. There was an apparent increase in the rental days under the new owner, and the current owner first rented the home in August of 2022. So based on the findings of fact, as noted above, in particular, point 5, the language of Article 4.6 of the Madison zoning ordinance, which presumably goes back to 1990, but is attested in 2015 version, supported by the definitions of the Madison zoning ordinance of motel and commercial use, as defined by Webster, do not permit short-term rentals. So based on the findings of fact as noted above, the Madison Zoning Board of Adjustment at the March 20th, 2024 moved to deny the appeal from the administrative decision by a roll call vote of 5-0. Does anybody feel that there's an inadequacy in this letter of decision? Could you pass that back to Kate? Jake?
No, I believe those findings of fact are factual.
Okay.
No, I believe that
Okay.
we didn't miss putting anything in there that would substantially affect. There are other things, we could probably have made that letter much longer if we wanted to, but.
Mhm. Okay, so in essence, since we're reconsidering a rehearing, does anybody have a reason to have heartburn over the decision? Because this is our last chance to say, do you want to rehear this case?
Yeah, no.
No.
Okay, can I entertain a motion to deny the rehearing?
So, okay.
Okay,
So-
Jake moved to deny the rehearing. Can we add some words to that because there's no new evidence and no apparent error in procedure?
Yes.
Yes, okay.
You want me to say it?
No,
No,
that's fine.
That's
Kate's
just for
got it.
Kate.
Okay.
Okay, issue and procedure.
I'll second.
Gotcha.
Okay, and then when you're done, read the motion and then we will vote.
Motion to deny the rehearing because no new evidence, I think we should say was presented, and no apparent issue in procedure.
Okay.
I added that.
Error, I would say error in procedure.
No, yeah,
No
okay.
issue.
No new evidence was presented and no apparent
Error.
Because-
error.
Yeah, because it's procedural
Procedure.
error.
Right.
Take our issue.
Okay.
Everybody good?
Mhm.
Roll call.
Okay, roll call vote.
Aye.
Aye. Jake?
Aye.
Jennifer?
Fine.
Okay. Okay, so we have denied the rehearing of case 2313. So if you desire, you could take it to the Housing Board of Appeals or the Superior Court. Okay, so now we have a whole series of other cases. Mr. Johnson, do you wish to table them or continue them to a date in the future?
I would wish to continue the request, thank you, Mr. Chair. I would ask that the remaining cases be continued to a date certain 6 months out from now, because that'll allow a little bit of the court process to play out, and we'll have a little better clarity whether any of these remaining ones become necessary or not, since ultimately the ZBA decisions you've made so far sort of raise the question of what the court has to decide, and they're either gonna agree with you guys or they're gonna agree with me.
Right.
And that's ultimately going to be
Right.
somewhat
It'll
outcome
be-
determinative on the rest of
exactly.
them.
Right, exactly.
I'd
So,
I'd rather, and just be clear, I'd rather continue to a date certain right now so we don't have to renotice them. I'm happy
that's fine.
to revisit if it becomes a lot longer, if we do something different. I'm happy to.
Yes, and we're very happy to entertain those kinds of procedural questions, right? I just, you know,
Yeah.
as I've indicated before, we'll stay in touch with each other, but the decisions are a board decision as opposed to, you know, chairman
Understood,
decision.
yeah.
Right.
But-
And I believe, is there not like a form that he's gonna need to
I'm
sign
just
because of the length of the request for the
concerned.
continuance so that we,
Oh, yeah, this
We
is,
are-
Concerned about the hearing date waiver.
yeah,
Yeah.
that's, because technically speaking, we have to make a decision within 90 days or dismiss the cases
Yeah, but
without.
I can
without
waive that.
prejudice.
You
But
can waive that.
Do
right?
you
But what
wanna
we would like you to do
waive that?
is put that signature on record so that if later they go to
Yeah.
court, there's no reason to cause us procedural problems.
That's reasonable.
Do you want to
Okay.
do it on the application that's here, or
What's that?
do you want to do it on the applications on each of the files here? Wait, because there's a,
What's gonna be easier, I'm happy to send an email to her with the
Listing.
list of cases saying I hereby waive
Okay.
the requirement for X, Y, you know, for the list
I
of
always make a
cases.
copy and put one in each file.
Yeah,
not
that's fine with me.
Something,
Yeah,
because I don't have
that's fine.
anything.
Right.
I'm happy to put it in writing though, that makes sense. I don't
Right,
have a
yeah, it's
problem
just
with
so that there's, nobody has a grounds for a procedural problem. Okay,
I
did
don't
you have a
problem with
question?
that.
I do.
Yes.
Can I come to the microphone?
One second.
1 second.
Can you make sure, Kate, that he gets the correct wording that we need to make sure that, like, I don't, not that I don't trust you, Mr. Johnson. I just think that instead of going back and forth, well, this isn't the wording that we need this wording. If you could provide him with the statement and he can put it,
It's right in the application, but I can send, want me to send that to you, Attorney Johnson, the actual language, like, I hereby waive the right to have, not your application.
That would be
but
perfect.
the application heard within,
Sure.
yeah.
we'll change it to, it says 30 days now, but we'll change it to,
Well, how about we just make it a generic, 6 months or the
Further continuance.
decision at a higher body regarding the other cases.
I mean, I'm okay with that. I mean, the new Superior, there is a land use
Yes,
judge
there
who's
is.
supposedly trying to do these quickly.
Yeah.
yeah, he's back.
That, very new, we don't know whether that,
And it's their definition of quickly as opposed
yes,
to
Yeah.
it's not
anybody
any
else's.
business person's definition.
Right.
Okay, all right,
I'll
so
send you
before,
Attorney
Yeah,
Johnson
and
the
I'll
language.
I'll cut it, I'll
I'll send it to you.
drop it into an email and send it back.
right,
Try to
and,
do it tonight.
and we need to address the question of these things. I assume we can group them, correct? It's like we have in the past.
Yeah,
Yes, okay, so what's your question?
I've got 2 points.
Yeah.
Number one is, if these cases are postponed for 6 months, and it does go to trial, and the applicant loses, what happens to all these fines that are potentially accruing from this past August, when those properties got their cease and desist letters?
There's a selectman.
That's a selectmen's issue. Generally, the town has been reasonable. That is, if they're continuing to rent, shall we say defiantly, the town is within its rights to enact the fines. If, on the other hand, the people are somewhat cooperative, the town is fully within its rights to minimize the fines, right? That's just not we're not an enforcement agency.
It's a select board.
It's a select board issue.
Okay. 'Cause
Right.
These cease and desist letters were issued after the third.
Well, that's right, but
August.
we have technically been in litigation, so there's
They
a
stopped.
reasonable grounds for the
Okay.
town to suspend accruing the fines.
Okay.
Unless, of course, there's some sort of aggravated, behavior on the part of the individuals, the town, we don't deal with that,
Okay.
okay, as this board.
Understood.
Okay.
Second point, now there's 5 cases pending that did not present any evidence whatsoever that they rented before March of 2022. And the fact that the property was historically a short-term rental was not used as one of Attorney Johnson's arguments. So these were all ones that
Yes, that's correct.
absolutely started after March of
Right.
2022. And there's no disagreement about that. So those 5 cases seem to be easily heard because the facts are so specific and are all aligned, and there's no, well, what date did he start renting, what did the ordinance say, and who said what? So the case 2319 on 1 Oak Ridge, I know for a fact never rented prior to March of 2022. 26 Little Shore, case 2320, was never a rental until after March of 2022. 17 Jungfrau, case 2322, was never a rental before March of 2022. 3 Grimsel, Mr. Kesselbeck, case 2324, was not a rental before March of 2022, or was 80 Oak Ridge, case 2325. So those 5 cases, I think Matt Johnson would agree, there's no rental history prior to March of 2022.
So you're saying they're not dependent on the outcome of the court cases?
Because there isn't one of those that the ZBA has heard yet.
Yeah, so to be transparent, we're not competent to make that decision without a hearing, okay? So our choice is to either honor Mr. Johnson's request to continue,
All the cases.
or we could, not, we could say, no, we're just gonna continue them till next month, But as I said, we haven't had a public hearing on any of those cases, so we're making a decision, shall I say, a little bit blind, because we haven't had a chance to get any input other than the application.
Okay.
In this case, it may seem on the surface that they're very straightforward, but each case has its own unique characteristics, and I'm simply saying that as chairman, without taking the time to look at those unique characteristics, I'm not sure that, if they're kind of suspended at the moment, the town is free to take action in the meantime, if they feel that they've got grounds.
And/or if they continue to rent?
Just,
Yeah. Right.
It's a cookie cutter appeal. They all say the exact same words, like to the letter,
Well,
and don't claim any rental prior to March of 2022. So just thinking that it would make sense to do those first, since there's not all this additional information with HOAs and dates and zoning ordinances.
right.
to
Mr.
take
Johnson,
into
what do you think?
consideration.
I think
Thank you.
I think it's more appropriate just to continue all of them. I mean, ultimately, the outcome of the other cases are probably going to drive that analysis of whether those cases go forward anyway. And so, and we'll see a little bit, and potentially those will get brought forward on an earlier date, but I think ultimately, even though the cases that are going up, they'll have the same legal issues, so ultimately those questions
Yeah.
may get answered anyway.
Right,
For
and-
those other cases by the court, and so those early court cases are probably going to answer the question for all of the pending administrative appeals.
Right, so on a pragmatic basis, by allowing these cases, we're not taking the owners off the hook for a potential fine, right? That still exists. But we are preventing taking the town's time hearing all those cases that might be decided by a court case and then would basically disappear one way or another. The owners might say, well, okay, the court decided against us, or the owners will say, oh, the court decided for us, so what we're doing is saving the ZBA's time as well. So, Mr. McKenna, do you want to,
I agree with everything you've just said, with the exception of one thing.
what?
Why wait 6 months? Everybody seems to think that something's going to be decided on the cases that have already been heard. Why not revisit this, your board, after 2 months, and then if they need 4 more after that, do it that way. I think we will know by 2 months as to if it's going to go forward, what cases are going to go forward. 6 months is way too long. And
Well,
Can
Mr.
I-
Johnson,
can I answer-
yes,
Can I answer that?
yeah.
Just, I hear your point, but it just, contextually, under the statute, I can't appeal a case until I've provided a motion of rehearing to the ZBA, and the ZBA has denied the rehearing. So the first one that I can appeal within the next 30 days is just because of this meeting. So there'll have to be one more meeting so that's why I picked 6 months, because it's gonna take a little while to get to the Superior Court. I can't do it any faster because there's a mandatory motion for rehearing process that
Well,
I have
right,
to follow,
and
or I
you-
can't appeal it.
No, and you've also said that should the court case decision be made earlier, you can
Sure.
always come back to us.
Right.
And, we can make a decision to either withdraw the cases or, act accordingly, or, renotice the cases and hear them 2 months earlier. There's all kinds of options ahead. So
Well, if I
think-
and the town attorney will know full well when exactly the court issues any decision, and
Right.
then the next step will be to revisit with the ZBA what that means.
Right, and so the answer is, this is an expedient means of saving time and energy. But the owners are not off the hook in terms of potential fines, and they understand that. Okay. What I'd like to do is move that we continue cases. I'm gonna just list them: 2314, 2316, 2317, 2319, 2320, 2322, 2323, 2324, and 2325 until the, what is that, 6 months from now is 1, 2, 3.
Sure, I
11
think you had one in there that's maybe not
Yeah, it's not
mine.
his.
Right, you have
25
yeah, you don't
is,
wanna put that in.
Yeah,
23 is
23.
Moscone, and that's
Yeah.
already.
Oh, yeah, I'm sorry, yeah,
I,
It's already been-
I would,
Kate, you
I
take-
already know to take it out. I was on it.
right, yeah, I was looking through there, you're right. So we've got, so we do have listed all the other ones, so we
Yeah.
want to
We have 8
move those.
cases.
This is May, so 1, 2,
6
3, 4,
months is
5, 6 would be November 20th. Here at 6 o'clock.
Thanksgiving.
Yeah, it's just before
It's before
Thanksgiving.
Thanksgiving, the Wednesday before.
Okay.
Drew, can I need a 2-minute comfort break.
Yes,
Can
let's
I be
vote on,
excused?
let's vote on this first, okay?
First, of course.
Okay. I move that we continue these cases till November 20th at 6 o'clock here in this building. Do we have a second?
Second,
Second, okay.
roll call vote.
Yeah.
Sharon Schilling, aye.
Drew, aye. Jake?
Jake,
Jennifer, I.
Yes, please, go.
Yeah.
Okay.
They
Okay,
asked me, and I
it is
told them
not
to
yet
wait.
9 o'clock. We will open the next case.
Right on the right on the corner, there's a light switch on the outside of the door.
Yep, invite Mr. Dempster back to the table.
Yes,
And
and
Mr.
Mr.
Olson.
Olson.
You guys need these.
Oh, I got it.
In fact, what we can do here, there's no reason to keep Jake on the phone, because we've got,
Unless you want 1, 2.
no, we'll have 5 people, assuming that, don't hang up yet. But if, Mark, are you willing to be raised up for voting member for this?
I don't have to be.
No, well, no, I want 5 members on the board, and Jake is on the telephone, and we have 5 people in the room.
Oh, okay.
So I can let Jake go, and then we'll elevate you and Bill and Jennifer, and we'll have 5 people on the
Well,
board.
Bill's already a
doesn't need
regular
to be.
You don't
member.
have to elevate me.
Right.
Oh, that's right, Bill,
You
sorry.
can, I'd like to be tall, but that's okay.
Yeah, right, sorry. Used to, forgotten to change the status here, excuse me. Okay, so Jake, you're excused.
I'm in.
You're excused.
wants to.
Thank you very much.
Thank you guys.
Just because I sat down next to him?
Yes.
Bye, Jake. Enjoy your vacation.
Thank you.
Call ended, okay. So Jennifer will be back in a second. let's see, let's just take a quick, hold on a second, let me get 14, 15, 13.
I know, right?
Yeah, hold on, this is 2403, right, and who all's
Here's
here?
18.
Yeah. Who all's here for,
04. 2404.
yes, 2404, oh,
Anyone for
03.
2403?
Right here.
Okay, alrighty.
Am I an alternate again?
So,
Am I an alternate now or still engaged?
No,
No.
we elevated you, didn't we?
yes, I'm on the
Still
elevation.
elevated, I stay elevated.
Not yet,
I
but
stay
he's gonna
elevated, yes.
What do I know?
Okay, Kate, this is case 2403. Will you read the notices and et cetera?
2403. Gee. Okay. Various requests from James Archamel, agent for Chelsea R. Gillis, trustee of the James and Bonnie Archamel Irrevocable Trust, 388 High Street, tax map 232, lot 34, from Article 5.9A, Section A of the zoning ordinance to build a garage that would be 60 feet from the center of, and mailings went out, certified mailings went out on April 24th. Everything's been good. The only one that didn't get returned was yours, but you can notice, so. And they were posted at the post office on the 24th of April, and they were posted in the Conway Daily Sun on April 25th.
Okay. Does anyone have conflict of interest?
No.
No.
No, okay. No conflict of interest on the board. A waiver request, I think
Yes.
there's a waiver request for this one. These are always awkward. The question is whether or not it's extremely critical for us to know the difference between the proposed 60 feet or 59 and a half feet, or whether, yeah, the question is whether let me ask, why was a certified plot plan not submitted?
I just felt that we were not imposing on any other abutters other than just the road itself. And where it was an easy measurement to obtain, I did it myself, where I've been in the building business for over 50 years and have done many of these in the past. I did remeasure it this spring again, just recently, and my numbers are right there. I'm measuring level, dropping a plumb valve, and no wind, and we're getting good reading. And that's why I felt that would be all right to do that. I did take the tax maps that you posted on the internet and use that as the guides for well, actually, all I did is I increased the size to fit 8.5 by 11 sheet of paper from the tax map to include just my property, and whited out what I didn't need, and went that route. I can show you my worksheets if needed.
Okay. How does the board feel?
Well, one of the contentions, I think, of this case is that the terrain is sloping and there's nowhere else to put this, and I think that a certified plot plan might at least give us a better idea of how this is sitting with regard to some of those things. So.
Yeah, I'm the same cut of cloth on this one, Sharon.
Yeah.
There's no known boundary markers, there's no rods, there's no pins, there's nothing official to give us something to go on. And if we're gonna make a decision on a variance that's gonna stay with the property for perpetuity, I'd rather have something, and I know we've had several cases before this where the guy said, well, I had a rope and a compass. And we've said, nah, that's
right.
not gonna go. I'm sure you're good at your craft. I'm in the construction business myself, but I built big skyscrapers. And so I'm sure your numbers are accurate, but I would rather, in my own personal feelings, I'd like to see some type of, surveying map or plot plan or something that has actual legal markers on the property.
Yeah.
The needle in this case, wouldn't it be the center of the road? It wouldn't, that's the only thing we need to apply to, where we're not abutting, the butters are all far enough away. It doesn't apply to the 75-foot setback. The only setback we're going after is from the center of the road. And that could be established very easily by either measuring the road or calling it 20 feet. The road actually does measure 20 foot 6 inches.
Yeah, I mean, yeah, if we just interrupt there for a second, the question we have to answer is it important that we know whether it's 60 feet, 60 feet 4 inches, 55 feet 13 inches? I mean, the primary issue here is that it's not 75 feet from the center of the road.
Right.
So that, I mean, we've often weighed the cost and time delay for a certified plot plan against the actual benefit to the town in knowing the precise
Right.
measurement. So that's a question that I think we could legitimately ask, I mean, we're within our rights to require a certified plot plan. But I think we also need to be able to say there is actually, other than the formal requirement, it's actually going to give us information that's critical to making a decision.
That's reasonable. I think a topo plan would help. I mean, I think some idea of the kind of the challenges that you're facing.
Is the picture adequate there for you?
Well, it doesn't look, well,
Doesn't
not
it-
really, because it looks as flat as a pancake in the photograph.
pretty
I mean,
flat.
It is pretty flat where the garage is going,
Yeah,
but as we go
but
to the
that's
road,
15 feet,
Oh,
but
I'm
15 feet away, don't worry.
this is, the road is here.
Yeah, I understand
Okay?
that.
It's
yeah.
just still here.
Yeah.
Can I interrupt here and have a point of order?
Yeah, we haven't sworn him in.
We haven't
No.
sworn him in, we don't know who
Sorry.
he is. No, that's okay.
Yeah, well, that's the point. We started the discussion of the
That's a
waiver
good
request, so we haven't gotten to that point yet. So, but let's do that. Let's go ahead and swear you in, because we have to get past this point or
Yeah.
decide we're gonna stop here.
Yeah,
Okay.
absolutely.
And let's see, Mr. Aruda, why don't I swear you in as well at this point, because you may have an opinion on this matter as well relative to this point. So, does anybody else want to speak to 2303? Okay. Now, it's highly unlikely that we're going to get to 2304 tonight.
Highly unlikely.
So you're welcome to stay, but I'm just kind of giving you a heads up.
Yeah.
Okay. Okay, so, oops, just a second. Raise your right hand. Do you swear that the testimony you give pertaining to this case will be truthful under the penalty of perjury? Okay. Okay, so let's go ahead and do you have a comment relative to the waiver request, Mr. Aruda?
I just have a comment about the project in itself.
Okay, well, we're not quite there yet. Let's figure out whether we need to,
So again, I go back to, again, the point in the application is that the reason it has to be located here, which is 60 feet from the road, not 75 feet from the road, is based on the topography of the land and based on the fact that it's sloping.
Right.
We don't have any information that shows that. So having a certified plot plan would give us that information to say, oh yeah, he's right, there's nowhere else on the piece of property you're gonna be able to put this. Or, no, there's no compelling reason to put this 60 feet. I mean, it could go either way, but without information, without that plot plan, we're absent information to make that decision.
how many of you made a site visit? Just out of curiosity.
I wasn't able to.
I've been by there many times going up the road, so I know where the property is.
Yeah. Okay, I did make a site visit. Let's step out of sequence here just a little bit. Mr. Aruda, what did you want to say about the?
Well, I've been up And I've been Jim's abutter for the last 25 years. And I drive High Street and North Division Road 4 times a day, every day. Everything on the east side of Hathaway Road is much closer than 75 feet to the center of the road. Every house, including my own property. That's just the way it is. It's not gonna change anything in that neighborhood at all. My garage is 15 feet from the center of the road. It was built back in the days before zoning. Jim is right next to me. We barely can see each other's house from the trees. You go down and you get the Shackers, that house is
Yeah, right on the road.
right on the road. You go the next one down, right on the road. You go the next one down, right on the road. I just think we're making them jump through hoops to do something that, I don't know, just doesn't make sense. And the properties do drop off. Both my house lot drops off. I only can use half of my property because it drops off. The property at Budding is, which is 18 North Division, drops off into the water. There's a stream in behind that property that goes all the way to Silver Lake. So, that's all I'm gonna say. I don't think it's that big a deal.
Yeah.
Even if you go up North Division, a good many of the houses all sit really close to the
Yeah, and I was gonna say, I did make a site visit, and I can corroborate the challenge of the drop-off. And part of that is that one of the reasons why it looks flat is because the driveway parking area has already been filled
Okay,
so that it's level,
fair enough.
right?
Yeah.
And so this is the effect of putting the garage, okay, just strictly speaking, the lot is plenty wide to put the garage 75 feet, you know, from the road center.
Yeah,
If one does that, then he'll have to fill in the driveway. You know, we're asking to move the garage 15 feet, which is half the width of the garage,
Yeah.
or an entire car length effectively. So what it boils down to is that then you have to fill in the driveway further down the hill, right? And as the hill drops, you know, I mean, you get what I'm saying. There's a lot of fill in there, right?
I understand.
I personally don't think requiring a certified plot plan is gonna give us information that's critical for the town to be able to say it's a reasonable request,
Okay.
right? Now, what we won't be able to say is that garage 60 feet from the edge of the road, or is it 58 feet from the edge of the road? Do you know what I mean? Because the road it's an old road, you've been up, you know, the edges are, you know, are crumbling, and, you know, where is the center of the road?
Yeah.
But it is less than 75. That's all we can take.
It's less than 75, right? So the question is, that's what I'm saying, is
And
that
greater than 0.
it's greater than 0 and less than 75, right? So,
What?
well, it's probably, it's
greater than-
probably somewhere between, to be really,
50 and 60.
really, yeah, 55 to 65 feet,
Yeah.
okay?
Somewhere
You know.
in there.
Right, I mean, is there a way of just saying as long as it doesn't get less than 55 or 52 or
Or
48 or 60? You know, if it's gonna be 60, it needs to be 60.
And we've
It
done-
can't be 58.
Yeah, we've done that. If I remember right, we did
Yeah,
that.
I mean,
One up
remember
in
this, yeah.
Washington Estates, there was a barn up there, said it can't be this.
Right. And
We
he's
can
done
make
his
a
measuring,
restriction,
so.
right,
yeah.
well, right, if he wants to put it at 60, if it's gonna be less than 60, and in 5 years, somebody comes, because they
Precedent.
resurface the road, and they say, you know, your barn is only 58
58.
feet, then he's gonna have to come back for
Yeah.
an equitable waiver. You know, so I would say,
Well, that's what I was saying, is there a cushion?
let's say, yes, we can build a cushion and just say 60 feet. However, if when the road is resurfaced,
The middle will always be the middle, though.
well, yeah,
I
well.
didn't say that. Yeah. Sorry, I know better than that. I know better.
That's like
than
80 and 80.
Yeah,
Okay,
I-
we can spend a lot of time on
Yeah.
this.
No.
I'm gonna move that we accept the waiver request.
I usually disagree with the chair on,
You're welcome to.
and I tend to agree with you on this one.
I see, okay.
So
Are you seconding the motion then?
I will second the motion.
Okay, all in favor? Aye.
Roll call.
Well, we don't have to
No,
do
we don't
roll
have
call,
to.
just
Aye.
Oh,
aye.
aye.
Any opposed? 2 opposed, 3
Oh,
in favor.
opposed? You have to state.
Bill and Sharon are opposed.
You have to state your reasons.
No, they don't.
Oh,
This is a waiver.
There's a
request.
waiver
Oh, waiver
request.
request. I'm
Yes.
yeah, sorry.
No.
2 opposed.
Yeah, okay, so the waiver request is accepted. Okay, so regional impact, does anyone think there's regional impact to this? I'm gonna take that as a no. Okay, so the rules of procedure we're well familiar with in this. So would you like to make a brief presentation as to what it is you wanna do so we know?
So I'm not gonna get it, in other words.
No, it's, they're just the, no.
Make a brief presentation on what you are asking for.
Oh, what I'm gonna,
Yeah, just tell us what it is.
What you wanna do.
What you
I
want.
wanna
What does
do.
the application say? But
The
you have to,
application.
you have to stand up,
Okay.
state your name.
This is for the
Please.
record for the
Alright.
town because you're on
Yeah.
I'm doing
television.
this,
and all
even
that.
though I've
That's
been doing
okay.
this building for 15
Yeah,
years.
and the reason you're at the microphone is because the people on television and on the tape can't hear you from there. So-
All right.
Okay.
My name is James Rothmel. I reside at 388 High Street, Silver Lake, New Hampshire. I'm looking for the variance to set my garage, new garage back to a 60-foot setback. In that garage setback, I did favor the town every time I took a measurement and didn't, you count every quarter inch. If there was 3 inches, it was 5 inches, or whatever it was, there's a factor built into that, as well as another foot I added just because I've been in the business for years. Knowing how people can move things, and even though I will set up string lines to give them their starting points for the face inside, to eliminate any problems like that. Hopefully from there, I would then purchase the building from the Valley Lumber, which is a panelized buildings where they will put the windows indoors in the walls, come preset the walls, and then put the attic truss on, and then put the metal roof on that. And that's how I plan to go forth with this.
Okay, any questions? I would make the observation, you didn't say that, but those 2 buildings, the sheds.
Oh, yeah, the
in the
shed.
picture there,
Yeah,
They will be removed.
they're being removed.
okay.
So there will be hopefully great site improvement. I think John will attest to that.
Okay. Any other questions?
Just one question, are you gonna pour a pad for this?
Oh, yeah.
Okay.
It'll be it won't be a foundation, but
That'll be
full
good.
frost walls.
Yep. Okay.
You're not gonna STR it?
No. Well, there is a thing upstairs, you never know. Just kidding, just kidding.
That waterhead stationers.
Oh, there you go.
Okay, then feel free to sit down if we have
No,
other questions.
Who's the other one?
And it shouldn't
What's that?
impact the road as well as either, because the driveway is established, the driveway entrance is established, and this is quite a ways from
So
that
the
driveway.
easement's existing.
So,
Okay, so the essence of this issue here is that the placement of the garage is there because even though if you try to look at the topography maps, it doesn't show a radical drop because, it does drop, it drops significantly enough that it would make a significantly, shall we say, from a construction perspective, it's not challenging, but it's more expensive.
Absolutely. I live on a hill.
Yeah. So, any other questions regarding this particular?
No.
Okay, well then let's review the 5 criteria. We have answers, provisional answers in the application, which we can accept as is and/or amend for our purposes. right now, we're just taking a look at them in case you have other questions. I mean, we'll deliberate in a few minutes, but I just want to take a look. The hardship issues related to the slope. And, you know, the usage issues, garage is a reasonable one. And there won't be any change to the character of the neighborhood, as John has already pointed out. So the question is, do we have any further particular questions? Otherwise, we can move to establishing our findings of fact and then close the public hearing and deliberate. No other particular question? Okay, then let's just, okay, so findings of fact. One. Homes and garages in the neighborhood mostly predate the 1987 ordinance, and so are generally much closer than 75 feet.
Do we know that, Mr. Chairman? Do we know if it predates the zoning or they all get variances?
All homes.
Whether, yeah,
Yeah, but just because it's an old home doesn't mean that
No,
the...
not mine, all the rest of the homes.
No, I
Well,
mean,
I
just
mean
because the
that-
homes are old doesn't mean that the garages or the barns were
well,
built
that's
at
one
the
of,
same
that's
time.
one of the oldest sections, well, you drive up there all the time. I mean,
Yeah, it's very old.
It's one of the older sections of Madison. I mean, those are all old farms and,
To be honest with you, sir, I have a 100-year-old Craftsman-style house that I modified 10 years ago, and it looks like it was built 100 years ago. So you can make it look old. That's my point.
oh, I see what you
Yeah,
mean.
and I'm
so-
just asking you, so somebody doesn't go back and say, hey, wait a minute, this is not true.
Yeah, this barn-
Well,
this
okay,
was
what
built
we're
last year.
going for here is characteristics of the neighborhood.
Yep, got it.
The characteristics of the neighborhood are not determined by how old the houses are necessarily, by the fact that they're all closer to the road. So
So why
you're
don't you
correct in
just
saying
say that?
that are mostly, it's a neighborhood,
Why can't we just say the characteristics of the neighborhood?
the homes and garages in the neighborhood mostly closer than, well, okay, characteristic of the neighborhood is,
Buildings are closer to the road.
right, characteristics of the neighborhood are that most buildings are already closer than 75 feet.
To the center of the road.
Yeah. To the land slopes so that,
So
I'm
it's
not
like-
even sure how you get out of your driveway. I had to put my truck in four-wheel drive to get out on a dry day.
It slopes away from the road, down away
Yeah,
from the
yeah.
road.
The land slopes so that the existing drive is mostly fill. And
Would require substantially more.
what's that?
It would require substantially.
Yeah,
more.
well, I'm just getting one piece at a time here. So the land slopes, so the existing drive is mostly fill, and the garage,
Has limited,
yeah, would be positioned,
Space.
yeah, would be positioned to use the existing filled drive and parking area. Okay, Jennifer, what was it you were saying?
Wasn't I just saying about the land slopes away from the
Yeah.
road, so that we understand, you know, 'cause some properties are built into the hill and you have to dig it in, some are,
Oh, yeah.
so it's actually sloping down away from the center of the
Yeah.
road.
Yeah, so that moving,
The location.
yeah, downhill
It'd need much heftier foundations.
Would
I mean,
require, yeah.
If it's that steep, you need caissons. I mean,
Substantial additional expense.
much greater expense
And
structure and expense.
for, yeah, for fill and structures. Okay. Is there anything else that's critical in this, in terms of facts? Well, yeah, we can say the existing
Buildings are being removed.
the existing sheds,
Two, are there two?
yeah, two, right?
sheds, yeah, I thought two.
The existing sheds will be replaced,
And we got,
enhancing,
the condition of not to be less than 60 feet.
That's not.
we can
in that-
do a condition, right now I'm doing findings of fact. Right. Okay, so, right now we got basically 4 findings of fact. Characteristics of the neighborhood, close to the road. Land slopes so the existing drive is already mostly fill, and the garage would be in a position to use that existing filled drive and parking area. The land slopes away so that moving downhill would require a much greater expense for fill and additional structure for the garage. And the existing sheds will be replaced, enhancing the ambiance of the property. Anything else that somebody
It's a
thinks?
garage.
What's that?
It's a
Ambient.
garage.
Ambiance, it's a garage.
It's
That's
a nice
kind of
looking
that's
garage
a very
based on the
subjective
drawing.
word.
Okay, well, you know,
It's gonna enhance the neighborhood as opposed to detract.
Just
yeah, there we go,
enhance the
okay.
property.
Well, who was it,
enhance
wasn't it
the
Ken Hughes that used to say if you live in New Hampshire, you have to have a garage?
That's, historically, that's true.
Yeah.
Well, it's a true statement, was it him that he that said?
Maybe it's not a finding of fact.
You don't want
If you
to.
live in New Hampshire, you must have a garage. Okay.
Or a rhino shed, apparently, that's the alternative.
Okay.
A quick question, Mr. Chairman. Should we put in a finding of fact that an abutter spoke in favor of?
Oh, sure.
Yeah, supports the application.
Well, I'd say the closest abutter to the,
Yeah, to the proposed location.
yeah, the new garage
Has no
supports-
objection, supports,
yeah, supports the project. Okay, anything else? If not, are you satisfied with those findings of fact? Okay. Motion to close the public hearing?
So moved.
And I'll second.
Catch that?
Just
Everybody
figure
spoke,
it
so
out.
just pick one.
Let Mark do it,
Sitting in the
because
audience all night.
You
Mark-
guys are testing me.
Mark motioned, Bill seconded.
I thought, okay.
I know, my voice was in there,
You
but that's
didn't
okay.
Yeah.
Gotta go on record as doing something.
Exactly.
I finally woke up.
Otherwise, they'll never know you were here unless they read at the top who was present.
Okay, so,
Okay,
all in favor, aye?
aye.
Oh, what,
Wait,
Closing the,
closing the public
closing
hearing.
public.
Yeah.
Yeah.
aye.
Okay, the public hearing is closed, which means we will debate at this point, so we won't have any further contributions from the public. Okay, so we'll look at the 5 criteria. He has suggested this is a sloping property that's typical of the neighborhood. We are asking for a variance to set the footprint of the garage in a partially flat area, which would be 60 feet from the center of the roadway versus 75 feet. According to the zoning ordinance, this location works well with the existing driveway, and there would be a minimum fill required. So, so the necessary hardship that what we're looking for is, you know,
Site condition, yeah.
the site, yeah, exactly, the site condition would require considerable
Considerable
more
additional
expense.
effort and expense.
Effort, yeah, considerable more effort and expense. When the proposed location is consistent with the neighborhood. Okay, so owing to special conditions, no fair substantial relationship exists to general purpose, which is true, so we just said that, so. Proposed use is a reasonable one owing to those identifiable special conditions because did not build a garage, the building would require a larger expense, deeper foundation, larger, well, yes, that's correct. Okay, the variance will not be contrary to public interest because there is not change to drainage or the roads. The proposed use will not impact nearby properties in any way. That's the spirit of the ordinance is observed because the natural setting between the garage and the road will not be disturbed. Between the road and the garage is a stone wall and sloping ground that limits view of the garage, keeping with the existing appearance of the property. Will enhance the property value, that's true, and this should add value to the property's granting variance of substantial justice because it will prevent unnecessary expenses. And allow use of existing drive and parking area. Okay. Any other additional comments there? No? Somebody want to propose a motion?
Do we want to propose?
Conditions?
Condition, well, that can be part of the motion.
Okay, I would propose a motion to accept this variance request on the condition that the building is no less than 60 feet.
No what?
No closer than 60 feet
Thank you.
To the center of the road,
to the center of the road.
or from the center of the road.
From the center.
Which, whatever is.
As a historical perspective, back when I was just a lad on the Conservation Commission, Richard Hawking said that he could remember the roads being rolled. And that's why your houses would be close to the road, because they'd roll the road and you'd want to be close to the road so you can get out.
Yeah, right.
Richard. Did you know Richard?
I did not. I know the people who bought his house, the one that the house on Bickford that he owned, and I know I've talked to Jesse Shackford about him going down there and working down there and doing all kinds of stuff for him, and
Back in the olden days.
and that barn is like this far from the road.
It's where you'd want it.
Although this day and age, they've hit it a couple times. It's almost impossible not to because the snow, as they're pushing it, pushes into the barn.
Okay, I'm gonna slightly adjust that, move to grant the variance because it allows efficient use of the existing field drive while enhancing the aesthetics
Of the property.
of the property on the condition that the building be no closer than 60 feet
To the,
to
from the center.
from the center of the road.
Of the current road.
Of
It's
the
like you
current
said,
road,
the
in
road
case they
could
change it.
move and shift. I don't know, I'm just being.
I'm gonna have you read it again.
Yeah, I will.
It was me tonight.
The middle of the road could be somewhere else. It could be
Yeah,
yours.
well, that's, yeah. Move to grant the variance because it allows efficient use of the existing filled drive while enhancing the aesthetics of the property. On the condition that the building be no closer than 60 feet from the center of the road.
Do you have to specify which edge, like building, what, the center point of the building, the corner of the building?
Any
No, the closest point.
Closest point.
This is the overhang.
Well, well, yeah, the footprint defines, yes, exactly. So 60 feet is the closest point, which is, the footprint is defined by the overhang. That's correct.
Second?
Are you seconding or you're
I
asking?
did, second,
Second?
second.
Okay, all in favor?
Aye.
Aye.
Aye, okay. Okay, so we have unanimously granted the variance request. It's 9:30.
Congratulations.
Go build your
Just 1 second, I got one formal thing to say, which you guys all know. If one wishes to appeal, one must act within 30 days of the date of this notice. Day one being tomorrow, necessary first step before any appeal may be taken to a higher court is to apply to the Board of Adjustment for a rehearing. The motion for a rehearing must set forth all the grounds on which to base your appeal. Board members are advised to refrain from any discussion with other board members or all parties until all appeal periods have expired. Thank you.
Thank you.
Let me just ask a dumb question. I know it's 9:30. Do you want to take 2304 tonight and be done with it?
Let me speak, my case is exactly the same
I was
as his,
gonna
and I
say.
have a survey done. So there's,
It's probably actually an easier case.
you're done,
to-
you got yours.
I'm willing to stick it out.
I'm willing to stick it out.
Right, I mean, we'll still be out of here.
Within-
Our rules and procedures say we want to end the meeting before 10, and I'm
So-
suspecting that,
We do
yes,
still have to review minutes.
yes, I know, but, you know, the reality is that this is not going to be a difficult case to address, I don't think.
Read it.
When can I apply for my building permit?
As soon as you get your letter.
For my letter.
Yeah, I mean,
5 days.
Kate could
Alright.
walk down the hall and tell Bob tomorrow morning that,
No, that's
It was
all right,
approved.
just an idea, so I can,
yeah, I mean,
wanna start calling my
officially, we
people.
have to sign the letter within 5 days. But like I said, Bob could ask Kate tomorrow if you're in there to go looking for a
I
bird.
still have to call people and get things set up, I was
Yeah.
just curious.
So you got a week or so.
Yeah.
Probably after Memorial Day before you can really do anything.
Yeah. That's all right, it works.
Okay, so,
So yes, we're gonna hear 2404.
yeah, let's go ahead and look at one.
Gregor, is that?
Gregoire.
Gregoire?
Thank you, I appreciate you guys taking the time for this.
Yeah, I mean, he sat here all night very patiently, and I think.
Out of mercy, right?
Yeah, well,
Mercy rule.
It's all thrilling
If-
stuff.
if the case were extremely complicated, we
would
might
say-
got a long ride
not have started it.
No,
but,
Are you staying up there?
yeah.
Yeah.
Oh, that is, yeah.
That's it.
Yeah.
Okay, so,
And this is on, for
2315.
29.2.
Can we like make a motion that we don't, while we get our easy ones, not complicated, really hard, take weeks and weeks ones?
You
Yeah,
can
we
join the
can-
planning board
You
then.
can,
I tried,
Don't
tried,
think I
they
hadn't
put,
thought about it.
agree with
I volunteered for it and they put me here.
Don't think I hadn't thought about it.
okay, so this is case 2304, correct, Kate?
2404.
2404.
I'm too stuck in the wrong, 2404,
They
that's,
all want to be younger, trust me.
okay, and this is May
15?
15th, okay. Kate, you want to read the public and personal notices?
Case 2404, variance request of Corey M. Gregor, 3 Bristol Stock Drive, tax map 108, lot 98, from Article 5, Section 5.9F of the zoning ordinance to permit an accessory building garage structure to impede upon 65 feet center line of the road from setback. Everything was posted, certified mails were mailed out on the 24th of April. I did get one back, and it said that this was to a Lawrence Fitzpatrick. It said, return to sender, attempted, not known, unable to forward. His address that you used, actually, it does match our records in Avatar, so he did do the correct address. I can't explain why the post office. I can't. If I could, I'd be making a lot more money, so I
So
don't
if I
know.
understood how the post office works, I don't have another.
So he did get noticed, according to our records in Avatar, where the tax bills are sent.
And it was sent to the PO box?
PO Box 520,
20,
Madison, New
Madison.
Hampshire.
Well, you may not
sorry,
have-
hold on, oops, sorry. PO Box 5, yeah,
520.
yep,
Yeah, well, he may not have been paid, he may have not paid for his PO box.
that could
and-
happen, it happened.
I think he's in Florida.
Well, he kind of forwarding address,
Right.
sorry.
Um,
So, didn't notice everything correctly.
well, if this were a highly
Contentious.
contentious case, I'd say we're stuck. But
But where
we could risk this one, I think.
we send it to it, you know?
Well, no,
We
my
don't
point
have
is,
one.
yeah, but, well, I mean, we'd have to do due diligence. First it came back, then we need to try
He
and,
must
Yeah.
get his tax bill somehow, because it comes out November.
Yeah, well,
it's not likely that he's gonna
Right.
appeal the case. And if he did,
we can
we
prove
send
due
a certified
diligence.
letter to the
It's the same
address on
place.
record. It's not an error in address.
Exactly what he gave me the correct address.
Yeah.
I verified it.
Yeah, okay, well, let's just make a note that, you know, we verified the address and it didn't work, so.
Okay,
Anybody have conflict of interest?
no,
Mark?
No.
No.
No, okay, so no conflict of interest. I do not. Waiver request, there's not a waiver request to this one, I understand.
Right.
We looked at there's a certified plot plan.
Thank
Does anyone think this has regional impact?
no.
No, okay, so let's swear, do you wish to speak as well?
Only if necessary. I'm a
A butter?
butter, I'm the immediate abutter, and I have no concerns.
Yeah,
I
okay.
was gonna say, might as well
Yeah.
swear
Yes,
in
yeah,
just
swear,
in
like,
case.
stand up and swear everybody in, and then if you decide you want to say something, then it's no problem. Wouldn't be a problem anyway, but. Okay, do you swear that the testimony you give pertaining to this case will be truthful under the penalty of perjury?
I do.
Okay, all right, thank you. All right, go ahead and explain your case briefly, but you need to
Yep.
come here for television.
Corey Gregoire, 3 Bristenstock Drive. So basically, I'm looking to seek approval for a building permit for a garage structure. Similar to what you just heard, there's quite a bit of an elevation change from the residence to the
Yes.
bottom of the property. If you look, it's about a 25-foot elevation change,
Yeah.
approximately 150 feet. Again, similar to what you just heard, there's a flat spot on the bottom of the base of the property, and the residence is at the top portion, so accessing the property during winter months is difficult, so that and keeping vehicles off of the main street, so that's a safety concern. And just having adequate storage, enough winter storage for things.
It's the aerial view of his property. I couldn't get there in person, so I
Oh, okay,
went on
yeah.
Google
Okay,
Maps
you got
and
that,
pulled
yeah.
it, yeah.
So,
The trees may cover the base portion, I'm not sure on that.
but the
This is-
garage is coming down here, right?
No, up here. This is
The house is
Bristenstock
down
Drive.
Wait a minute, I'm
Oh,
holding
you're
mine
upside
up.
down?
No,
Yeah,
that's it
there's
right there.
Bristenstock Drive.
Yeah, so the
Right,
garage
so
is
the
down
garage
here.
is up in this flat area, I presume.
Yeah.
That's
Correct.
cleared area.
Correct.
And you have a big
Down in here, and that would be
Yeah,
the
I
driveway
got it.
going
So
up
that's
to the,
fine.
that was an
Oh, so that's the
existing
leg of the drive there, I
So you
got
look at
it.
this. This is
Gazebo?
our-
gazebo.
Yeah.
Is
Yes.
it, it's still
Yeah.
there?
No,
So he's putting a leg of it.
it was an eyesore.
He's actually gonna put a
And,
leg.
yeah,
So you're gonna
and
put it up in here?
So we're underneath the gazebo where
So
those
it's
trees
tight
are in
there,
this
then.
photograph. then
Correct, so
There's
that's
like a
where you
stone-
see those trees, there's a large elevation gain
Yeah.
going up to where that gazebo is. And the driveway is to the left of the property,
Yeah.
facing it off the street. So basically, the driveway, you'd come off the driveway. So it's the only
Yeah,
feasible
that's
spot to
right.
come off the driveway.
Let's see.
Right. And that,
That's tight.
did anybody have a chance to go do a site visit?
No.
I did.
You did. I did too, so, I mean, there's a big rock wall that you've, right?
Just retainage
with
for now,
bank,
yeah. Yeah, that we just put to retain.
Right.
So eventually that foundation would actually, those rocks would move and the foundation can fill in and retain that portion.
Mhm.
Yeah.
So this garage is gonna abut to
Abut,
an
right.
elevation.
Exactly, so that's as far back as I can push that against that slope.
Can you explain to me the garage doors on the back then?
Oh, that's just storage doors, that's just back storage
Okay.
off of it. Yeah,
It looked
it's
like
probably,
you
it's two, like
drive
two double
through.
doors that,
Oh.
yeah.
So
How's he driving through?
how close is the closest corner there?
29 point,
29.2.
29.2.
so, yeah.
And what's it required there, 40 feet? I can't remember.
65.
65. Oh,
Everything
yeah,
else
I see.
fits within the setback.
Yeah.
Okay,
And that corner that's 29 is actually slab, there's no building, is that just you've just got
That
a
is,
slab?
I believe, the garage corner.
Oh, it is, the
Yeah,
building?
there,
I thought maybe you had
let me
like
look
a
at- if you
deck
don't mind.
slab.
Oh, I'm sorry, it could be a slab, yeah, so,
it's that
The
little
actual
alcove
building.
area, isn't it?
Yeah, so.
yes, that's actually a slab, so there's a
There's a roof
post,
over
and
it,
it's,
yeah.
yes, correct,
Yeah,
and it's a
there's
drive
roof
under, so.
over it though, so
yes.
it reads as that
And
mass.
it's
Correct.
this part right here.
Exactly,
It's the
yes.
same mass, yeah.
Yes.
Yeah, I'm just looking at the massing,
Yep,
basically.
yep,
Just because it's not got walls doesn't
Correct.
lose the massing, the roof massing, is there?
No, right, yeah, so, yeah, on our definitions here are,
Yeah,
the footprint is,
the massing. Yeah.
right, but,
It's three-dimensional
Just-
at that point even.
yes, it is.
Yeah.
Yeah, and just for just Jennifer's new, so it also includes, our footprint definition includes any decks,
And overhang,
sidewalks, overhangs, all that sort of
steps
stuff.
that
Yeah.
come down.
so it's a
Right.
concrete slab.
Yep.
that-
Part,
Yep,
anything
got
that's part of the structure,
Yeah,
yeah, part
I
is
can
part of the
read drawings,
footprint,
not a problem.
yeah. Okay, okay, any other specific questions? from the board?
The 29 feet, there's absolutely no way you can get it
We're already,
without.
we're already pushing it back into the slope, they're actually digging, so I'm actually,
You're on rock.
everything's gonna be a frost wall, and that wall actually, because we're pushing it into the
Yeah.
slope, that wall's actually gonna stand 5 or 6 feet high. So we're increasing the size of the frost wall there because there's so much fill,
Okay,
backfill there.
got it.
Yeah.
Yep, understood. So you're actually going into rock at that point?
Yeah,
you're
where,
not
so
just-
where you, who did the site visit, wherever, saw all the rocks there, that literally is gonna get all excavated out so we can put the foundation in. Yeah,
Oh.
that's how
Welcome to
tight,
glacial region.
that's how tight I'm pushing it to the side, yeah.
Mhm.
I think she drew it, if you look right on the, just the elevation
Yeah.
of the,
so that-
you can see, kind of see, that there's a rock, that's basically to mimic the rock wall.
Uh-huh.
Yeah.
So yeah, there's, without building 10-foot concrete
Yeah.
walls, that's, we're
I
pushing
get
into the
it.
slope.
Okay.
Mhm.
So, no, I have no more questions.
Mark?
So
is
there's
there-
nowhere else within the building envelope that this fits?
Correct, because if you look at the contour lines on the, you're up
That's a
against
pretty-
Yeah,
that.
even if you
Pretty
flip
hefty
to drive. God
The only
forbid,
thing you can
yeah.
do is move it front or
Yeah.
back, but I mean, at that point, we're already
Yeah.
within the setbacks, so it's,
Well, then you'd be moving your driveway to the corner and you'd be, yeah, don't even.
yeah, there's no gain.
Yeah.
You can do this for $30,000?
I'm the contractor.
Even still for
That's
30,000
still
bucks.
quite impressive.
I saw that too, Mark,
I
I'm like,
think I'm gonna have a go on.
Site work on the
I'm
foundation,
gonna
dude,
build my
it's
house.
30,000.
I think I put that in before things escalated.
Oh, they escalated.
Yeah.
Yeah.
It's really 1990 something.
Ah, funny.
Trying to build a 12 by 12 addition, and I think I'm gonna spend $30,000.
Yes. Probably are. Yeah, okay.
Okay, so, all right, let's just, you can sit down. Anybody, let's just collect the findings of fact.
And just a question, Mr. Chairman?
Sure.
Did
Yes.
you want to say something on the record?
Only, I noticed in your last piece that you mentioned that an
Name.
abutter was.
Your name?
Who is he?
Yeah, your
I'm
name?
sorry, John Conley.
John Conley, okay.
You mentioned, you back to finding, in fact, the last one you mentioned that an abutter was in support.
Mhm.
I am at 3 Rhinark. On the map, I was at 5 Bristol Stock, which would be, so it just happens to be a corner lot. We did a voluntary address change, and we attested to a 30% grade on Bristol Stock, which is what, again, similar to what he has, so that's why we went around the corner with our driveway. It won't affect our sight lines, and if you've done a site visit, you've seen the kind of property that he maintains. In full disclosure, there is a familial relationship between us, so I'm not trying to hide anything in that conversation.
So you're this house down here, right now?
I'm the house it's under construction at the
okay.
corner of Reinhardt and Bristol Stock.
I don't think it's on, I
Oh,
don't
Oh, it's
think
not in
it's
here,
in
yeah,
this.
it would
Yeah,
be
it's
up
just
here.
too old.
It would be over here.
If that has the
Oh, this is
gazebo, my house wouldn't be.
2024.
Okay.
Okay.
Map dated imagery 2024.
No, don't believe it.
Google Lives.
Apple's better, Apple's more up to date.
Well, probably what happened was, there's a section of the thing that was taken in 2024, 10%. Yeah, where the sun glinted off of something.
So
that
he's
was
up in,
disturbed.
he's up in here.
So if I may ask a question, I'm not gonna put words in your mouth, but you don't see any problems with this work that the applicant is applying for?
It won't affect our sight lines, it will improve the quality of the property, and anything that he has outside today would end up being inside, which would be a benefit to all of the neighbors.
There you go.
Okay.
All right.
Thank you.
So, okay, so findings of fact is that there is no other place,
Yeah, due to the grade of the gradient.
yeah, no other location on the lot. How big is that lot, by the way?
Pretty
Sizable.
It's really good. size.
0.82 acres?
Oh, it's not that big.
Oh, it's a big
I
lot
think it
for up
just
there.
looks big.
Uh,
I mean, technically,
Yeah, when you look at this, you can, it is a big
could
lot.
put it right here, but
Well, yeah, right on your porch.
yeah, right. But I was gonna say, but
Yeah, no.
Yeah. So I'm gonna say there really no other location on
No
the property.
feasible
It's,
area.
No other feasible location. The existing, yeah, the construction will require excavating some of the incline as it is. Okay, anything else that's, anybody wanna throw anything in there? I mean, this is,
Well, last time we said something about it enhancing
the neighborhood.
I don't know if that's finding a fact or just an opinion.
well, we will include that in the 5 criteria.
It's in keeping with structures, other structures in the neighborhood with regard to
Mhm.
size,
Yep, height,
location,
pitch.
height, all that.
The pitch is gonna match your house pitch, the roof pitch.
Everything's, yeah, it's very similar to that.
No, that's really our business.
You didn't build me a garage.
Well, in one sense, it's not our business, but it is our business in as far as things don't change the character of the neighborhood.
Yeah, that's true. Yeah.
Right, so if you wanted to build, what would you call it?
An airplane hangar.
An airplane hangar.
Right.
Or
Right.
an Anderson, yeah.
Or, yeah,
Like
something that was
getting out of it.
architecturally radically,
Damn.
If anything,
Well, I
that keeps
wanted to
in
build a glass
character to
box.
what the house is, the
Yeah.
roof
Yeah.
lines,
Yeah.
everything is.
Yeah, like if you wanted to build a big metal cylinder.
So I wasn't going off on a
silo
tangent,
kind
or I
of
can, I
thing.
don't want to.
Stacked metal containers as my garage.
Oh, I've done a couple of places with containers. I've designed
If you
lots around
clad them
containers.
properly.
Not in the rural area, but I,
okay, so if there's no other questions, do we want to close the public hearing?
I motion that we close the public hearing.
Second.
All in favor?
Aye.
Aye, okay, so we will go to, let's see what we have here. think we can accept point A of his, point 1 is the gradient contour of the residence.
Yeah.
Yeah, and, yeah, and point B, is pretty well the proposed use. C here is reasonable, north side and the rear.
Bless you.
Yeah, okay,
Your
so
leg
that's
was
good.
wearing off.
No negative impact, not because, yeah, well,
To public
okay.
interest, it doesn't affect
Well, it's
drainage.
consistent with the neighborhood.
There's no rainwater issues next to
Too much of a slope.
I
Yeah.
was gonna say.
Well, it's going somewhere. Gravity
Not
always
for me,
wins.
but anybody below me.
Well,
Spirit of the ordinance, yeah, I think we basically just accept
Yeah.
these as they are.
Yeah.
Are there any conditions that we need to consider imposing?
that it's no less than that distance, the same kind of condition that we did before, that 29 feet.
Although in this case, because we have a certified plot plan.
That's true, yes.
It's not.
That's
29.2 feet is pretty.
Pretty
pretty
accurate.
damn exact.
Yeah,
Yeah, no, that's fine.
Yeah, and we, yes, although you are correct in the idea that in any variance, the board has the right to impose a reasonable restriction. If we feel that, whatever.
It doesn't suddenly want to start tipping onto the sidewalk such
Yeah,
as there is.
okay.
Got it.
Reasonable restriction, we can't say as long as it's painted chartreuse.
Planning can.
Okay. All right. Shall we, let's see, move to grant
Yeah,
the variance because it is a reasonable use
This is a private road?
property.
No, it's part of my place.
Yes, yeah.
It's a private way per town of Madison and state of New Hampshire records. So it's owned by Village District of Idlewild.
Village District, that's part, yeah.
So, okay, move to grant the variance because it is a reasonable use of the property consistent with the character of the neighborhood. And there is no other feasible location for the garage on the property. Okay, so moved.
So moved.
Second.
Bill seconds, okay, all in favor?
Aye.
Aye, okay, so we grant this variance.
Thank you guys, I appreciate staying late for this.
Yeah, and then let me read it. Yeah, well, All right, so hold on one second, you have to listen to this formality. If one wishes to appeal, I don't know why you would.
No, somebody else.
One must act within 30 days of the date of this notice, day one being tomorrow. The necessary first step before any appeal may be taken to higher court is to apply to the Board of Adjustment for a rehearing. A motion for rehearing must set forth all the grounds on which one will base the appeal. Board members are advised to refrain from any discussion of the appeal with other board members or any party to the appeal until all appeal periods have expired. Thank you.
Now go home.
Thank you guys.
Have a good
Thanks, Ryan.
night. Thank you for being patient.
Thank you for volunteering.
I'm beginning to wonder about that.
Yeah.
And this is only your second meeting.
Yeah, but I've been to Concord for an entire day. That was fun. And I've been
Yeah,
on
how was
Zoom
it?
and dry.
No
Oh.
doubt.
was fine.
Did you go to the other one?
I
I
learned
did
a lot.
not.
And I was on the Zoom on Saturday. as well.
Oh, you were on that
Yeah,
one too?
for Chris's bit.
Christmas
Yeah.
Bolt.
Oh, you were there?
I was online.
Oh, yeah, so
Yeah.
was I. We-
Yeah.
We didn't see
We
it,
didn't see it.
yeah.
Yeah.
Oh.
I don't know why, because I have a Zoom
I
name,
saw
it's
Bill.
mine, but yeah. Yeah, I was on from about 10 till about lunch, until they all broke up for lunch.
Okay, so we need to approve the minutes.
Yeah, very,
Um,
here somewhere.
So, let's see, whoever's, let me pull out my,
Gosh, I do.
that's why I couldn't find the minutes.
So it was you, Jake, Bill, and me. Jennifer was here, too.
Yeah, so technically,
And George.
yeah.
Right, but he's not here tonight.
Oh, tonight, right, sorry.
Yeah, so technically, Bill and Mark cannot vote on those portions of the minutes which cover items for which they were recused,
Mark can't vote on anything.
because it's too late? or because-
Well, he wasn't here.
Oh, yeah,
Yeah, he
you
was
weren't there,
excused,
yeah,
yeah.
that's right,
So I have a question, Mr. Chairman.
yes.
If I can't vote, but can I make corrections?
Yeah,
Especially if
well,
they're
you were in the
grammatical
meeting,
ones.
yeah, sure, you
Yeah.
could.
Okay.
yes, Yeah, yeah, so if you see an error,
You probably couldn't change the thought process of saying this doesn't accurate, but you can change grammar. You're not
Okay.
gonna vote on them, you're just gonna recommend, you're just
Right.
gonna.
so do you have corrections?
I do from me.
I do.
Yes, go ahead.
What do you wanna start with?
Yeah,
me?
let's start,
Okay.
yeah.
Second page, at the top, underneath public hearing, it says Gentile confirmed stated.
Oh, that case.
Pick one.
Not-
Either confirmed or stated. Okay, and then, the paragraph that starts Gentile asked, Gentile, is it?
Gentiles, I would
Gentile,
say.
okay. Asked Attorney Johnson to restate his case.
Yeah,
The next line, Attorney Johnson stated he represented the Kellermans.
Yeah.
Strike it, because it says again, right after it, Attorney Johnson stated he represents the Kellermans.
I get carried away.
Mm.
Okay. 1, 2, 3, 4, fifth line after that, halfway across the line, it says Attorney Johnson stated.
Oh, where are we?
The Mr. Kellerman.
Where? Where?
2 lines under where it's in bold, 2315, almost directly underneath that, it says Attorney Johnson stated the Mr. Kellerman, should be that.
Attorney Johnson, where are we? Stated that he represents, wait, which paragraph are we in?
They're right in the
That
middle
same
there,
paragraph, see
That-
where it says
right
bold
there.
2315, case 2315, it's in bold?
Oh, yes, stated.
2 lines underneath that, stated
Mr.
that,
Johnson.
Stated
yeah.
Sorry,
that.
Stated that.
That's okay.
You actually don't even need that, you can just state it,
Yeah,
Mr.
stated
Kellerman.
Mr. Kellerman, I'll
Yeah.
take it right out completely. Stated Mr. Kellerman, okay.
Yeah,
1, 2, 3 more lines after that, it starts with Kellerman's acquired
yeah,
in December
The property.
202.
yeah, that would be,
Property in 2000.
it just, a
It
Kellerman's acquired
testified that the
December.
property the Kellerman's
22.
acquired in December 202, it should be 20,
22, yeah.
yeah,
Won't go again.
I
What
know,
happens
right.
when you're doing them at 11 o'clock at night?
Yeah.
And that Mr. Kellerman has operated the property in the same manner. Yeah, there's a bunch of little. Go a couple more lines down that starts with applications.
Third line from the bottom,
Should be a period, strike the word and, make he capitalized.
yeah.
After the word, couple more words down the line, it says we are now on to the facts. It should be insert and specific aspects, same line.
And specific
What was it?
aspect.
Facts and specific aspects.
And,
Okay, next line down, after the word analysis, insert a comma.
First word on the sentence, on
Is
that
it-
line.
what?
After the word analysis.
It's in a
See
quote.
that? It's not in a
Attorney
quote.
Johnson's factual background and legal analysis according below.
No,
Where are you?
No,
the second to last line in the
What-
same
what page?
paragraph.
it's the same page, starts on
Paragraph.
page 2.
Oh,
The
here,
word
I'm sorry.
analysis, insert a comma,
Between that.
included in the
Yeah.
letter. Analysis, comma, included in the letter. Okay? I'm good with the page 3, I'm on page 4. Um, 3/4 of the way down the page, in that big paragraph, Attorney Johnson stated he wanted to make some legal points. All the way down, the line that starts with March, comma, 2022 zoning ordinance.
By the selectmen's view.
Yeah,
At the end of that, it says states that short-term rentals and a single-family home.
yep.
It should say short-term rentals of a single-family home. Next, page 5. Second paragraph. 1, 2, 3, 4, 5th line down that begins with alternate and let Martin stay. It says, however, Gentile has already done this. He already did what? It didn't make sense to me.
Yeah.
Gentile stated he's willing to do this and allow
Already
Scaife to
done this.
be the alternate and let Martin stay. However, Gentile has already done this. Well, what had he already done?
Yeah,
Oh, I had already
Let-
elevated,
Right.
Okay,
I had already elevated Jennifer.
so why don't we,
I've already-
Gentile had already elevated
Okay.
Scaife.
yeah.
He asked.
Yeah.
All the way down the bottom under the Keith Kellerman, 21 Haven Road.
Yeah.
1, 2, 3, 4th line down. That starts with the property, and to also rent the property for short-term rental. To offset costs in purchasing a second home.
Of their retirement plan, that's what he said.
As part of their
He said
retirement plan.
it is, but I'll change it however you want.
Purchasing a second home.
As part of their retirement
Wait,
plan.
oh, maybe I'm not. Hang on, and this is a benefit for them. Oh, I'm sorry. The line above that, right above that, at the very end of it, above the word second home, it says benefit for them.
To
It
use.
should have two in the to use
Yeah.
as
Yeah.
opposed to just use. On the next page, 6, big paragraph, Gentile stated that this is a review of an administrative decision. Go all the way down to where it says Conway versus Kudrick is lined. The line right above that, short-term rental is like a business which Attorney Johnson does not believe you can like. I don't know what that means, that you can like under the Conway versus Kudrick decision.
I don't know what that means.
I don't know what we're.
Even saying hypothetically you did. Yeah, that whole thing doesn't quite come together.
It is under the contract, it is under the Conway versus Kushner decision.
But even saying hypothetically you did, the ordinance said,
So you're saying it should say Attorney Johnson does not believe it is under the Conway versus
Right.
Kudrick decision.
And hypothetically, yes.
but even saying hypothetically you did, it's very conversational.
So we're striking you can like,
Yeah.
and we're inserting it is.
Yes. That makes sense, that
Okay,
does.
under the Conway Kudrick, but even saying hypothetically, you did, the ordinance already says you can have home occupations. Okay?
Yep.
Next page, in the paragraph about Bill Dempster,
Yep. What'd I do?
the second little in the first paragraph, the 1, 2, 3, 4, 5, 6th line down, the line starts with 1987. Stated what is permitted in that area, and in 1994 it was broken up into, and then you have the word to. It just needs to,
Into
just
what
strike
was.
it, just, yeah, into what was permitted and what was permitted by special exception.
What was permitted?
By special exception, that's fine.
Oh,
That-
I thought you were asking me to add
Yeah,
that.
nope,
I
nope.
already did that.
Yeah,
Okay,
just strike the word to.
yeah.
The next little sentence or little paragraph, the one sentence,
Yeah,
it's after 1969 to 2015, and the word the.
yeah, take it out. It's all good.
That's all I have for that section. Did you have more on that section, Bill?
Do I?
Yeah.
No.
Okay. I didn't know if you, because I know you said about me.
The next section.
The section that starts with Martin asked if under the regulation,
Which page?
Page
are you on?
oh, the next page, page 8. The paragraph that starts with Martin asked if under the regulation, I think this whole paragraph is,
Well, Martin asked if under the regulation.
Martin asked if
It
under
is
the
specified.
is specified.
Is it specified, or it is, or?
It is.
It is specified, okay, so insert the word it.
Well, that's a question because after that says Dempster stated, yes, it does.
You
Okay,
should
so,
put if it is specified. Martin asked.
Is it specified?
so just put the word it after is.
Yeah.
Is
okay.
it specified?
Yep.
And with a question mark at the
Yeah.
end.
And a question mark. Dempster stated, yes, it does. Gentile stated, which will tell what is required under home occupation. I don't understand the which will
Yeah.
tell.
No. Stated the regulation will tell what is required under home occupation? I don't know.
Yes,
Yes.
under the regulation. Is
Well,
it
it's there.
specified? Gentile stated. Maybe if you change which to it, that the regulation then,
Yeah.
it will tell what is required under home occupation?
Yeah, then you're actually got the subjective, yeah.
Yeah. I was trying to figure out what I said too.
You were there, yeah.
And I think the rest of it is okay. That, I just didn't understand what that sentence was trying to do. The rest of the page, I'm good. Page 9, I'm good. Page 10, the big first paragraph, the third line from the bottom, halfway across the line, it says supersedes as 2 words.
One word.
Should be 1 word.
Okay, I spell checked all this too.
Yeah, right?
Where-
Spell check
where are
doesn't-
we?
Third, this big paragraph on the top,
Yeah.
the third line from the bottom.
Oh, feel like.
Right in the middle.
Yeah, I did spell check it.
Yeah.
Well, super and seeds are both words, so
Right.
they're each spelled correctly.
Could you pause for 1 second? I actually have to put a new SD card in.
Sure.
It's been a long meeting. Who they were.
Talk about
I don't see the red light.
Yeah, go ahead.
Oh, there we
there
go,
we go.
okay.
Thanks.
All right.
Okay, clear space.
The next paragraph down, the second line, there's a period after the word facts that doesn't need to be there. I think it's either a period or a comma or something.
comma.
I wrote-
The board needs to look at.
I wrote over it.
Second, the very
Board
first
needs
word.
facts.
You see it?
You want me to take it out?
Yes.
Just let it flow.
Under the preliminary findings of fact, item number 4, the HOA charter foresees rentals.
That's came from Drew. so
Is
I
that
don't
from
know
you,
if he
Drew?
wants to
Did you use the
change
word
that.
foresees?
I think so.
Yeah,
Okay.
I take his stuff and cut and paste it.
Okay.
Okay.
Is it, you don't like the word, or you,
Well, it looks into the future. It's
Yeah, I don't know that the HOA charter could foresee anything.
states,
It talked about, it indicated.
refers to, indicated.
Refers to,
Yeah.
yeah.
You could say permits.
Allows.
Well, they would foresee that their members might rent
Yeah, that's true.
either long or short term.
Yeah, leave it alone. True.
I mean, if it's what he wrote, we'll leave it.
Yeah,
Yeah,
I
yeah.
Yeah, we'll leave it. I'm not that picky.
That's okay.
That's it for that page. I'm good for page 11. I'm good for page 12.
Excellent.
13 is legal analysis, it's not yours. On 14,
Yep.
down the bottom of the page, the next to last line says, house now clarifies as a short-term rental is a permissive use. Attorney Johnson is arguing that a single-family house now, I think it's supposed to be
Oh,
classifies.
sorry.
Yeah, I think you're right.
Can't wait until they blow us all out of the water.
Yeah. Yeah, that wasn't.
Next
very
page,
popular.
15, in the Jennifer Swift.
Maybe nervous
Gotcha.
there for a minute.
Swift stated that in the,
Stated in.
take
the-
out,
see,
take out the
this is
second,
this.
stated that in A.
Stated that in the cease and desist letter, it was a deceased, Swift stated that
In
the
the,
cease-
and then take out stated that in a.
Oh, yeah, I took that out, yeah.
Okay.
No, I made it work right.
Okay, that's it for that page. On page 16, in the paragraph that starts with Attorney Johnson stated, go down 1, 2, 3, 4, 5, 6, 7 lines. That line starts with zoning ordinance. The next 4 words don't make sense. Zoning ordinance that says predate that.
That sounds like a separation from what's in zoning. There's nothing else in the zoning ordinance
Else
that
is
says.
That predates that,
That
that has any restrictions on renting a single family home.
No,
There's
can't
nothing
say
else in
it.
the zoning ordinance.
That predates that without the says.
I don't know what we're trying to, dwelling.
No.
Nothing else in the zoning ordinance that says.
Well, the zoning ordinance that predates that says. I don't know.
Also, the zoning ordinance predates that.
yeah, I think we
I'd
take
just
the
take out the
says out.
I
says,
think
yeah.
it's the
Says
says
out.
that's throwing it here. Yeah.
And I think you add an S to predate.
Yeah.
That
Predates.
predates that.
Yeah.
Gotcha.
Yeah.
I have nothing on page 17 and nothing on page 18. I'm done.
Hallelujah.
Anybody else have anything else?
I got a simple one.
Good.
Which one, Bill?
Page 14,
Okay.
where it has Bill Dempster, 57 Doe Drive.
Yeah.
Go to the last sentence.
Dempster further
Dempster
he
further
does
stated he
not
does not like grandfathering.
Right.
That's not what I said. I went back and looked at the video 3 times to make sure.
What'd you
What
say?
what I said was, Dempster further stated that he does not like the term grandfathering, but prefers pre-existing non-conforming use.
Does not
What
like
prefers?
the
term.
term.
The term grandfathering,
Mm-hmm.
And
but prefers pre-existing non-conforming use.
Yeah. I'm doing that.
My granddaughter today.
Wow.
what is it?
Oh, you're talking about grandfathers, and I saw my granddaughter today.
That's all I
How old
have.
is she?
Gee, almost two.
Nice.
Okay, so Kate, do we have any other administrative business we need to take care of tonight?
Well, I sent all of you on May 8th at 6:46 a.m. Probably weren't all looking at emails then, but I was here. I said, see below if anyone is interested. Bill and I talked, I sent it to him too. The planning and zoning alert, action alert, the House Bill 1291, that's up for, that would mandate municipalities allow 2 ADUs per lot everywhere that single-family homes are allowed. So I also sent it to the planning board as well, because it affects both boards. I had heard from Jake, and he said maybe we should write a letter to our senator. And then Bill said, should you do it individually or as a board? And I'm just putting up, I don't know what you guys want to do. If you want to do anything, it's up to you. But
Well, I think that,
when I see
I
things
did,
like this, I point it
I
out.
did write to Jeb, right?
Jim Bradley,
Yeah. On all three cases, and mentioned I was chairman of the zoning board.
Okay.
Okay.
On the other hand, I also recommend anyone who feels strongly about any of those to also write individually.
Okay.
Yeah, because sometimes, sometimes they'll pull letters out randomly, and sometimes they'll count, you know what I mean? And so, if they're just counting, and, we send just a letter as a board, that,
Well,
And
letter.
I just, when I see these things come across my email, I want to pass them along because they affect
yeah, no, that's fine.
outcomes for both planning and zoning. So I see them and I send them.
I got sent that directly from, after going to that seminar, they sent me it as well as you did, so.
Yeah, I get everything. Because I took the class Saturday too. I did the thing with Bill and you, so.
Okay, well,
We had a vote on the minutes.
oh,
You haven't
I'm
even
sorry.
done that yet,
Yeah, we
so
haven't
wait
done
a
it.
minute.
Right.
I make a motion to accept the minutes from April 17th, 2024 as amended.
Second. All in favor?
Aye.
Aye.
Well, that's
Those
three,
guys
they
They're all
can't.
grammatical things, so I'm not gonna list out all.
No.
If I try to do that, I'll be,
Yeah.
so I'm just.
So you want to put in as grammatically amended? That way they know they were all grammar
Yeah.
issues.
Amended due to grammatical errors.
Yeah, there was no content issue,
No.
except for his.
Well, and
So
it
who
wasn't
voted on
really
that?
content.
You,
Jennifer, Drew, and I, they
I
could.
can't vote.
right.
Right.
No.
Perfect, that's what I want to catch, thank you. I'm losing my
It's
voice.
a good question. Do we not vote or do we abstain?
You can't vote?
Right. No, don't abstain. An abstention,
Carries something.
Mhm.
Means something.
yeah, it means something, yeah, but it doesn't, you're not voting because you weren't there.
Right.
So abstaining is,
It's something
unless you
else.
want to say I'm abstaining because I was not present, but then not voting is, yeah.
Carries the same.
Okay,
Jake does that when he's not present for a meeting.
yeah. Any other business?
I don't have anything.
Motion to adjourn?
Second.
All in favor?
Aye.
Okay.